Good morning, Mr. Kwakwa.
Good morning, CJ.
How are you?
I'm blessed and you?
I'm fine, thank you.
Thank you.
Are you ready to start?
Yes.
As ready as can be.
Yes.
All right. That's
Yes.
good enough.
All right. Yes, thank
You have two law degrees, a BUris and LLB, obtained from Walter Sisulu University,
That's correct, CJ.
right?
That's correct.
But obtained when it was still the University of Transkei.
Yes, it was the University of Transkei. You always say humble. You always honor the humble beginnings.
Yes,
Those were my humble beginnings.
indeed.
Yes.
You have also undergone other training, though. What else have you? You have is it a certificate in dispute resolution in labor matters? Is the
Yes.
diploma? What is it exactly?
Yes. I attended a course of labor dispute. I think it was in Devon. Yes. So it was just an attendance.
Oh, I see. And you've also undergone the aspirant judges training program.
Yes, I think that was last year.
More
January.
recently, yeah. In January 2024, your application form says.
Yes, I did attend that aspirant judges course. Yes. I
Okay.
think for a week.
Okay. You're an attorney
Yes, an attorney. I was admitted somewhere
in 1995.
1998,
Oh,
November.
you did articles in 1995, 96.
Yes, I started
Then,
at Pierre Gachun,
yes.
Ikopo, and then I went to Pietermaritzburg. I studied articles to Pietermaritzburg at AM Muligo. Muligo, you'll remember, he was a judge as well at KZN.
I remember him.
Yes, so he was my principal.
Oh, I see.
Yes.
And you have practiced and
Sorry, Chief Justice. I wonder if the candidate could put the microphone next to his.
Oh.
I'm struggling to hear.
just bring your mic closer to you. We don't have very good sound equipment here.
Okay, my voice is very low, so I'll try and raise it.
That's better.
Yes.
You are currently a managing director in your own firm,
Yes, MS Kwakwa and Associates.
which you started in 2000 already.
Yes, correct, CJ.
All right. You have acted, you've had various acting stints in the High Court.
Yes, I started in October 2023. Yes.
And how many terms have
I think if you combine all the weeks, I think it's 29 weeks,
you? 29
which
weeks.
is equivalent to 6 months to 2 weeks.
All right. And all these acting stints were in
And
both Durban and Maritzburg.
Devon and Pietermaritzburg.
Okay. And how have you found that experience?
Very interesting, and it was, a good exposure. I did not expect to be given such an opportunity. However, I grabbed it by both hands, and I dedicated myself and said, look, let me be a servant, serve the nation and serve judiciary at the best that I can. So it was beautiful. It was awesome.
What kind of practice do you run? Is it general practice?
Commercial work, I deal with most municipal work. I've been on the panel for various municipalities. So I do a lot of work for municipalities. So, like,
And RAF work as well, according to your form. Road accident fund work.
come again today, can I?
Road accident fund work.
Yes.
That's what we call it.
Yes, I do road.
Medical negligence
Exactly, yeah.
lawsuits.
Yes, I'm on the panel currently with the KZN MEC Department of Health.
And what kind of cases have you been exposed to during your acting stints? Has it been the whole gamut?
During my acting stint,
Uh-huh.
civil, you will find the applications for sequestrations as well as provisional sequestration. I got an experience there to deal with those matters, which deals with insolvency, So I dealt with those matters, extensively. So
You've sat in motion court, opposed, unopposed.
oppo- opposed matters and unopposed, you will get your divorce matters, you will get your application for mortgage bond, to declare them executable. So you'll get a variety of matters,
You've conducted civil trials.
Yes, I did IRF matters and marriages, uh, and the what you call it, okay, there are so many matters that I dealt with. Divorce matters, I've dealt with liquidation. I've already counted that. I've dealt with. They cannot come up in my mind now.
No, that's
but
all right.
a variety of matters. Yes.
And criminal trials?
Criminal trials, yes, I did.
And you've produced judgments, written judgments.
Come again?
Have you produced any written judgments?
Yes, I think they are about, if my memory serves me well, there are approximately 33 judgments that I've delivered. And I've got only one which was reserved on the 19th of or 18th of September 2025.
Last month.
That is on the last session that we had for September, for August and September.
Okay. Do you have any reported judgments?
I have checked with Safri and my secretary that assisted me in Durban. I think I counted about 9 or 12, somewhere there, that are on Safri. Yes.
All right. All right. I'll hand over to Judge President Boyodlot to put questions to you and the rest of the commissioners, of course. JP?
Thank you, CJ. Good morning, Mr. Kwakwa.
Good morning, JP.
Yes. You've acted for about 36 weeks, and I heard you saying to the CJ, it was quite interesting. I just want to know, how did you find the colleagues with that I work with? Did they assist you, or how did you find them?
Oh yeah, they were very welcoming, and you always say you get experience from the older colleagues that are there in the field. So it was very cordial and receptive and accommodative. So whatever question that one wants in terms of jurisprudence and just getting to know the the importance of respecting the other colleagues and conducting yourself as a judge and how to approach matters. If you have difficulties, you approach them, guide you. So I did find it very welcoming, and it assisted me to adjust and then to understand the importance of holding that important office of being a judge, because once you take an oath, you become a judge. We are no longer taken as AJ. You take an office, you uphold the law, you uphold justice. You just apply yourself, in a good way. So yeah, it was quite interesting.
Yes. And you said you sat in appeals and you were a scrub in some. How were the comments that you received from the presiders? Because I would imagine the presiders would have been sitting judges. What were the comments with regard to your draft judgments, to your judgments?
Oh yeah, no, they were very welcoming, and they guided me. So everything was done according to the script, So um, it was very interesting and educative, and it gave me another picture. That if you are in this field, you apply the law according to the book. So yeah, it was good.
Perhaps there on appeals, what would be the difference between a full court and a full bench?
Come again?
What would be the difference between a full court and a full bench?
Or appeals, I think it's 2 judges. Full court 3.
Full bench two?
Full bench, sorry.
Yes.
Yes.
Okay, all right. And your average time for handing down judgments, what has it been?
You could
And what is the longest that you have taken?
1 to 3 months, if you say. Yeah, I think the average, you could say 1 to 3 months.
All right. And one of the comments, I think from the GCP, was that you were not able to efficiently and effectively handle JCM roles. Perhaps you can just explain briefly what the JCM role entails, and what do you say about that comment?
JCM roles are matters that relate to RF matters, that they make an application to have matters ready for trial. So you look at the rules, whether there's compliance with the rules, like your Rule 37, joint minutes, and whether the matter is ready for trial. So you look of the compliance. You can't certify a matter ready for trial when there's non-compliance of Rule 37, there's non-compliance of joint minutes, there's non-compliance of discovery, and so on and so on. So you look at all those things. I think I read the comment and where it says I am shy. Well, shy is another thing. Knowledge of the law is another thing. It doesn't mean that if you don't comment, it means we are not conversant with the jurisprudence of the law. We are not conversant and understanding of what is expected of you.
When they say you looked overwhelmed and did not have sufficient grasp of the issues.
I think it's a misconception. The observer or whosoever observed me, I think he only looked at one side, because I queried some of the matters that were not ready for trial. So I did contribute, So it's not that I was just a lame sheep that is sitting there without any contribution. So there was kind of a contribution. So I understand what it means. I've been doing RAF for years, So I understand when matters are ready for trial. I understand when there's non-compliance. I understand the issues that need to be looked at. So I read the papers before. I write my notes, and I comment and tell the practitioners, have you looked at this? Have you looked at that? So I do have an understanding of what is required. So, and I give guidance from that.
Yes. Sorry, just on the reserve judgments, at the time that you submitted your application, you had one.
Yes.
Do you have any outstanding judgment other than the one for September?
That outstanding judgment was delivered on the 1st of September 2025. So it's cleared. It's only one that is outstanding, which was reserved on the 18th of September 2025.
Yes. In section 4 of your application, on that first question, you said you were behind with your bond and rental lease payments. What is the position now?
I've sold my house and it's waiting for registration. Once I receive the proceeds of the sale, I should be able to pay all my debts, So
So you're not coming to the bench for financial security?
no, I'm not bankrupt
Okay. Yes.
at all.
Now, just two issues on points of law. Is a Rule 43 application order appealable?
What is it?
Is a Rule 43 application order appealable?
No, can't.
Sorry?
No,
It's not,
No,
yes.
it's not, yes.
And in a matter that is urgent, and you find that the matter lacks urgency, what is the appropriate order to grant?
Okay, you look at, that is Rule 60, subsection 12. You look at the urgency, whether the matter is urgent. You look at the requirements, because now the
No, the question, I know, the question
Oh,
is, what is the appropriate order you grant when you have found that it is not urgent?
if it's not urgent,
Yes.
strike it off
Yes,
with cost.
yes. All right,
Don't forget cost,
all right. And then,
punitive cost sometimes.
yes, just on the matter, on the judgment that you attached, the first judgment, I think it involves the Minister of Police. The order you grant there is in terms of the notice of motion. Why did you not itemize what the notice of motion says? Because if somebody now is reading your judgment, you want them to have the notice of motion. Why didn't you just itemize what is the order that you are granting?
I think it was access to information. What I wanted to highlight was the rule of law, was to uphold the rule of law.
No, I understand.
Yes.
My question is, the order you are granting, it says you grant an order in terms of the notice of motion.
Yes.
Yes. So I'm saying, why didn't you say, I'm granting the order for access to information instead of saying notice of motion? Because you now want the reader to have access to the notice of motion
Yes.
before determining exactly what the order is.
Okay, maybe I might have not done, correctly, if I may say. Yeah.
There's room for improvement in
Yes,
terms
there-
of the style.
Yes, there's room for improvement. Yes.
All right. And then the complaint by Mr. Matenjwa, I'm not going to get into much detail about it, but I just want to ask this question. Is it likely that you might be called as a witness in that matter?
No. There is-
Why do you say no?
Okay, I was in the panel for Shatuza Water. As a presiding officer, I was appointed. So in his case, and there was an AG report that came from the AG that consequences must follow, in investigations and consequences. So my recommendation was that because he was on a final written warning, so I recommended that he must be dismissed. I think he was disgruntled by that decision. So there's nothing pending against me. I've not been arrested. I'm not appearing in the court. There's just absolutely nothing that is pending.
So the case I'm referring to is the case before the High Court that involves both
Oh.
Mr. Duze and Mr. Mhlanga,
There's-
and the trial has not commenced.
I have not been approached, and I don't think I will be approached.
Yes.
For the last 4 years, 5 years?
Well, it has not commenced for one reason or the other. So,
Well,
yeah.
I don't have any evidence to give. I was just a consultant,
Yeah.
so
All right.
it's unlikely.
Okay. Thank you, CJ. That's all for now, CJ. If I might be allowed, if need around, to ask other follow-up questions. But that's
Of
all
course.
for now.
Thank you, Shaky. Premier?
Thank you, CJ. No, I'm covered.
Got to welcome you formally. It's good to have you back with us again. Welcome. Minister?
Thank you very much, CJ. Good morning, Mr. Gwagwa.
Good morning, Minister. How are you?
I'm well and you.
I'm blessed.
Yes. Let me follow up on what JP raised with you. If you look at the comments by is it GCB, they do pick up two cases on the roll. Legal Practice Council versus MS Gwagwa. Are you able to explain those for us?
All right. When I read that question, it was in a present form. I think 4 years ago, 2021, 19 February, I was suspended by LPC. The reason why the reason of my suspension is because there was a letter that was written to me and I could not respond because of time constraint. Then the LPC took a decision to suspend me pending the investigations. So subsequent to that, I made an urgent application to uplift that suspension, which resulted into a negotiation between my legal team and the LPC. Then I went and I attended a inspection committee which recommended the upliftment of my suspension in September 2021, somewhere there. So eventually there was a recommendation of the upliftment of the suspension. So the question, I understood the question in the present form, hence I answered in that form.
Maybe just take us to what was the matter about? Because Legal Practice Council deals with conduct of practitioners.
Okay, it was
Now, if you have previous case of misconduct, whether the suspension was lifted, but what was LPC concerned about when they wrote you a letter?
it wasn't a misconduct per se. It was non-responsive to the letter that was addressed to me. So hence the LPC took a decision to suspend me. The complaint was,
What's the letter about?
yes, I'm getting there. The complaint was pertaining to the delay of finalizing the estate of late Blias Mabaso. So the complainant was saying, I'm not paying the rates, I'm not showing them the LNT account, which was false. That was the main complaint. So it wasn't about embezzlement of funds, no. It was just, those petty issues which were eventually addressed when the committee sat. They found that there was. Oh, by the way, let me also hasten to mention that that LNT account was accepted by the master of the High Court. Hence, I made an application to uplift the suspension. So it was about, not informing the family of the deceased, which was not correct. I'm not sure whether I've answered your question.
You have, and I'll go on with it. So the family complained because they said that you had not informed them, meaning that you were not diligent in your work. That's what they were alleging. That because of interaction, because if you're doing your work, corresponding with the family would be important as a legal representative. That's what I'm trying to ascertain.
No, you see.
Was it?
No, it's not correct. There were kids that were at school where I normally pay school fees, and they were kept updated of all the events. They came to my office time and again, and I showed them. It's just, you cannot control a person, and if one wishes to lay a complaint, everyone is at liberty to do so. So hence the master accepted the what you call the LNT account. So, and then one asked what was the complaint about, So there was a consultation with the Mabaso family. My office is always free. I mean, it's always open for consultation and information. I think that woman was just disgruntled, So we did not see eye to eye. So you know
This was the widow, the
Come-
woman you are referring to.
come again.
Is it the widow? Who is this woman? You're saying that woman was disgruntled. Who is the woman?
Yo, I just forgot the name.
What is the status of the woman within the whole thing?
Status of the woman.
Of the woman. You spoke about children, you were paying for the children.
Yes.
Now I'm assuming when you say the woman, I'm assuming it's the mother of the children.
No, it's the brother of the deceased. Sorry, so it's a sister of the deceased. Sorry, point of correction.
Sorry?
It's a sister of the deceased.
It's the sister of the deceased
Yes,
that
that-
complained against you.
Yes.
That wrote that letter.
Yes.
Mr. Kwangwa, the reason why I'm drilling into the matter, it also goes to what JP was raising, because for me, it's paying attention to detail of your work and being diligent. If they are saying that you were saying that it's an observation of a person in the court with the comment that the JP just asked you about earlier on, about I want to go back to it, because I want to link that between that and this area, and also how you're responding in terms of, because if you have a client, perhaps one would want you to say, this is a client, is disgruntled, I've addressed it in this manner. Now you're saying it's this woman. Yeah, but I'll leave it into that. The issue of JCM in terms of observation, because for me, then it becomes a pattern of communication, being able to articulate, engage, and it goes to the issues of interpersonal skills. Whether you do think that there's a concern around that, in your ability to be able to communicate properly, to interact properly, either with colleagues or with clients. Maybe that will be my last one.
Okay, must I comment? Must I answer?
Yes, please.
Oh no. Like I said, the observation of a person cannot be conclusive. It's an observation that needs me to respond. And to add to my submission, I did not receive any complaint of my inability to articulate myself in terms of jurisprudence, in terms of understanding the JCM, in terms of knowledge. Like I said, my experience in RF Matters dates back from, say, when I opened my office 25 years ago. So you look into that, I know RF, I've done, I've done it from the beginning, from when I say beginning, issuing of letter of demand, summons, and pleadings and so on. So I understand what is needed when you are sitting there doing the JCM. I understand the jurisprudence. I understand the non-compliance. I understand the rule of law. So I could interact with the legal practitioners and advise them that, look, you have not complied with section so and so, so please comply. There are no joint minutes here. There's no pre-trial conference. You can't ask for trial when there is non-compliance. So I understand the logistics of what is required of a presiding officer, if I may say. So it's just one of those complaints, But like I said, there was no complaint raised by any practitioner that I'm not satisfied with this acting judge. He does not know the jurisprudence or what. It's just an observation. Because if you look at the comment, they say I'm shy. Shy meaning we are not knowledgeable in law. No,
Thank you, CJ.
JP, that is.
Thank you, CJ. My name is Tugwawa.
Morning, Commissioner.
Yeah. You place me in a difficult position to understand this issue with the Legal Practice Council. You say the suspension related to what?
I said there was a recommendation by legal counsel
Recommendation
to suspend.
to suspend.
Yes,
You were never suspended.
I was suspended.
But then it's not a recommendation. There was a suspension.
Yes, there was a suspension.
Yes. What was it about?
They were saying I was okay. You know, they first made a report that they had to guard against the estate. That there is a suspicion that there is an embezzlement of funds. There is a suspicion of not handling the estate in a correct way. You know, they write all those things. But
I don't know. That's why I'm asking. What
yes,
was it about?
I'm trying to remember because I've not read it for 4 years. But it was about a suspicion, not a report with tangible evidence. It was based on suspicion,
Who had a suspicion?
LPC.
The LPC.
Yes.
Was it not pursuant to a complaint which was lodged against you?
It was pursuant to a complaint, yes, because like I said, the reason why they took a decision to suspend is because I did not respond to the first letter that was written to me
By
by LPC to respond to the complaint. I did not respond to the complaint, so that is why they deemed it fit that they should make an application to the High Court for my suspension. But remember, the suspension was based on, should I say, delay of finalizing the estate. But all of that was cured by the master of the High Court, who accepted the account, the LNT account.
failure to respond to correspondence as an attorney's misconduct. Are you aware?
Come again?
Failure to respond to correspondence as a practicing attorney is misconduct.
Yes,
You are aware?
yes,
It's not a suspicion.
yes, I'm aware.
Yes. There are time frames within which you must finalize the administration of an estate, a deceased estate,
Yes.
in terms of the Act.
Yes,
And failure to do so also is misconduct.
yes.
Yes. And then there was that litigation against you. You say it was settled.
There was litigation. There was a suspension, and then I did an urgent application, subsequent to that suspension. It was done within, say, 6 months or so. So if you combine, the suspension was in February, and then in September was an application, before September, and say about June, July, there was an application to uplift that suspension. And then there was an agreement that I must attend the inspection committee, which recommended the upliftment of the suspension in September,
Yeah.
or early September. Yeah.
But the acceptance of the liquidation and distribution account by the master does not cure the misconduct which had already been committed.
Well, when you say misconduct, okay, under normal circumstances, the estate must be winded up within 6 months. If you don't meet the target, it doesn't necessarily mean that that is the misconduct. That's your understanding. So I have a different view because there might be some challenges that contribute to the delay of the estate. So it's not necessarily a misconduct, but it's just a delay that must be explained.
But then you must get an extension of time from the master. You apply for that.
Yes, I did.
Yes, which
Yes.
you did not do in this instance, as I understand.
No, I visited the master because from time to time I had to visit the master and attend to the queries that were raised by the master, and those queries were cured, and then hence the master accepted the LNT account, you know, which prompted me to make an urgent application that, look, I have now complied with the outstanding issues that were raised by the master. So the account was accepted. Hence, I had to do this urgent application.
Yeah. One of the difficult issues is that your failure to disclose this crucial information has led to you and I now debating on this matter. Something that should not happen.
Well, if one read the question, you see, in a criminal court, you are always asked, the accused is always asked, any previous convictions? And then he discloses it. Any pending cases? The question is general, you know, and if I may add, I think during June or May, I applied for a certificate of good standing at LPC, and it was issued, which means there is no pending issues of misconduct. How can the LPC issue a certificate of good standing? Now, I have to think 4 years back and disclose and explain what happened. My mind was on the present, you know, so I couldn't mention something that happened 5 years ago. So unfortunately, my thinking, my understanding was in the present. Hence, I answered in that fashion.
But it doesn't say in the present, it says, has any legal professional body ever found you guilty of any
But now,
unprofessional or
our,
disgraceful conduct?
but I was not found guilty. Remember the inspection committee recommended the upliftment. I was not called before a disciplinary hearing and found guilty of misconduct. No. So it's a different thing. It's the way you understand it. The only thing that happened is the suspension. Suspension doesn't mean that you are guilty.
Okay.
Suspension means you are being investigated. You are innocent until proven guilty. I don't have any misconduct from LPC, not a single.
Yeah. You see, with professional conduct, it doesn't have to be presumption of innocence, as I understand it, but how you conduct yourself. That's the standard in a criminal court, like we were now mentioning criminal case. But for the integrity and conduct, I don't think so, but you are entitled to your opinion. Thank you, Chief Justice.
Thank you, JP. Professor Marumagai?
CJ, may I just ask a follow-up on JP Tlaleti's question?
Yes.
Yes, just on this issue of suspension, I assume that notice was given to you of the proceedings by the LPC.
Yes,
Did you defend the application?
it was defended.
And the judge granted the order despite you?
In fact, I even acquired the services of an advocate to ask for a postponement
Why? Why did you ask for postponement?
in order to file the accepted LNT account. So that was refused.
But had you filed your answering affidavit
Yes, I did. Yes.
and the matter was argued and the judge granted a suspension order?
Yes.
All right, thank you. Thank you, CJ.
Prof?
Thank you, CJ. Good morning, Mr. Gwagwa. I'm here.
Oh, sorry. Yes.
Yes. Can I please refer you to page 10, typed 10 of your bundle? I think on our side is page 14 of the paginated.
Is it on this one? This one?
I would not know. I would think perhaps the huge one, it will be page 14, I would think. Then the small one will be page 10, yes.
So, is it
But
this
anyway,
one?
just to not waste time, there is a case that appears there. It is a Rule 43 case. You remember that case that you did at Peter Marisburg?
Rule 43.
It is, I'm not sure if I'm pronouncing the word correctly, moon versus moon or man versus man. It was delivered it was heard on the 2nd of August and delivered on the 12th of November 2024.
Yes.
You remember that case?
Yes, I remember.
Yes. I had a chance to read that case. And I just want to raise certain things with you just to get your response.
Yes.
First and foremost, when one looks at the Pietermaritzburg Court, there is an issue about prolixity in Rule 43 applications. And the most recent judgment in that court seems to suggest that when the issue of prolixity seems to appear, the matter must be struck off the roll. But it doesn't appear as if you have a problem of that issue in this case. What I want to ask you about is, when one considers a Rule 43 application, what is the actual test that must be used to determine whether the interim maintenance sought and the contribution to legal costs sought are warranted under the circumstances? And I'm asking you this question because it doesn't seem to me, when I'm reading the judgment, that you actually undertook the exercise of determining the respective earnings of the parties. When I read it, paragraph 5, 15, and 10, it seems to me that you just accepted the version of the applicant, even though both parties were business people. I could not really understand your approach in that case. What is the actual test when you are considering a Rule 43 application? Particularly, I'm concerned with maintenance, not so much about legal contribution.
I think in that case, if my memory serves me well, it was about I think two issues. One, it was about the maintenance as well as the custody. You know, the yes.
Okay.
Wanted to,
What I'm asking is, in fact, it was about maintenance and contribution to costs.
Yes.
Those are the two issues before the court. But I'm more concerned about the maintenance part. I want to understand your understanding of the route that you need to take to say this party must pay interim maintenance to this one pending the finalization of the divorce. That's just the test. I want to understand the test part.
I think it's about the affordability. You know, first you have to check whether you have to check whether the should I say the respondent is earning money. Sorry, is salaried or is gainfully employed. That's you have to, because you can't grant an order when the respondent is not gainfully employed. We have to check that, you know, because there might be an application, and then once you assess that the respondent is not gainfully employed, what's the point of granting an order that won't serve any purpose? So you have to check that first. So two, you have to check the amount that is claimed against the respondent. You know, so you have to calculate whether does the respondent, or should I say, is the respondent able to pay that amount? Then you have to make some calculations, because in the application there should be some pay slip, you know, that will guide you in determining the amount that is claimed. If I remember, the respondent was gainfully employed. He was getting enough salary or money to maintain. So my understanding was to look into that first, and then see to it that is the amount of money available, because there were scenarios that were put by both parties, calculations that were made. So in order to give an understanding and a determination by the court to decide whether is that amount available, is it appropriate. Even the respondent considered that he's employed, and how much is he earning. So there was, a clear picture for the court to make a decision.
Sorry, CJ, can I just do one follow-up?
Bear in mind that we have 6 other candidates to
Yes, just a
interview
small
today
one.
still.
And I apologize. I struggle with that explanation because one, in the judgment, you state that in paragraph 26 that you concede, you state that there's no pay slip in this matter.
Hello?
There's no pay slip in this matter, in that paragraph. But what I've struggled with is because you need to go and try to understand both the means and the expenses of the person before you actually make them pay maintenance. And you look at the other person's means and needs. But it doesn't seem like that exercise you have engaged with in this case. But I will leave it there. Okay. Thank you very much, CJ.
Sorry, Chief
Is
Justice.
there follow-up?
Yes. Maybe not. Let me not. It's actually not a follow-up, but it's a follow-up to the other questions.
Okay, put them hastily, Commissioner Nkaito.
Thank you. Mr. Kwagwa, can you just explain to us whether you think it's appropriate to refer to Mrs. Mabaso as that woman who was disgruntled?
Maybe for lack of a better word, because I've forgotten her name. So my apologies if I put it in a wrong way. So my apologies.
No, but what do you mean if you put it in a wrong way? I mean, this was your former client that entrusted you with a very sensitive family matter of an estate. And when the minister is asking you, you say, well, that woman is disgruntled. And then when I ask you, you say, well, if you were wrong, then you apologize. I don't really understand that. And
just
one of the
forgot-
things we need to evaluate is judicial temperament and demeanor.
I just forgot the name, Commissioner. I should have mentioned her by her name. So my sincere apology if I've failed to mention her name. I have respect for women, so so my apologies if I've not addressed it correctly.
Well, at the risk of breaking my own rule that we should try to be, quick about these things. Referring to someone as flippantly as that woman, you could have referred to her even without mentioning her name in a more respectful way.
Yes, no, my
Without
apologies.
mentioning her name.
I accept that. Thank you.
Did you have another follow-up, Commissioner Nkaito? Was that the only issue?
No, Chief Justice, thank you.
Commissioner Mangen?
Thank you, CJ. Good morning, Mr. Kwakwa.
Good morning, Commissioner.
I'm also troubled by the responses that you gave to the questions put to you by the Minister and JP Tlaleti. Depending on your response to my question, I may want to probe it further, but let me ask you this question. Do you appreciate the seriousness of this matter? The seriousness of the finding by the LPC to suspend you pending investigations?
Yes, I know the implication.
If you did, and the GCB had warned you that this is an important matter that the JSC may need to probe you further on, why did you not find it necessary to take the JSC into confidence and make copies of the application and your response to this body?
Eventually, I did that. Hence, I responded to the application that was filed in court. you know. So I answered all the allegations that were leveled against me. So it was not just a matter that was unopposed, it was opposed. So I followed the protocol. I engaged counsel. We replied. You know, we filed every necessary document that was needed. So I complied.
Did you make those copies available to the JSC?
They were not. They were not. You see, there are two issues here. My understanding of question 4 was in the present. So I did not. I only answered the questions that were raised in terms of question, I think question 4, yeah. But there was a response, or should I say, answering affidavit that was filed in court with regards to that application for suspension.
Thank you. Thanks, CJ. I may have wanted to follow up, but I can leave it at that.
Thank you, Commissioner. Commissioner Shivan?
Thank you, Chief Justice. Mr. Gwakwa, on page 12 of your application form, in question, the answer 9 in point 9.5, the question is, please list any reserved judgment still outstanding and the dates on which judgment was reserved. You mentioned 2 cases there. Am I right? You mentioned Robert Feldegg versus Frederick Wilhelm, and then below that is Gerard versus Warner. And you go on to say that application for sequestration, you put 1 case number, and then the explanation is judgment was reserved on the 14th of March, 2025 at PMB High Court. Draft is completed, still with the researcher. The judge president earlier asked you, is that judgment, is your answer that judgment was delivered on the 1st of September? The sequestration one. I'm just seeking clarity on your answer to the judge president,
Okay.
Dawati.
There were 2 applications, one for sequestration and the one for liquidation. The one for liquidation was delivered earlier, and then the one for sequestration was delivered on the 1st of September. So both of them were delivered.
So was it 1 case or 2 cases?
2 cases, sorry.
2 separate cases.
Yes, 2 separate cases.
And you say that the 14 March judgment was delivered on 1st of September. Is that what you say?
The one for sequestration, it was delivered on the 1st of September. But the one for liquidation, it was delivered earlier, I think June or July.
But if you take that 14 March date, if you're saying that's delivered, that's a lapse of 5 to 6 months
14th
after the hearing.
14th of March was the date that both judgments were reserved.
But delivered 7 months later, 6 to 7 months later.
Well, March, April, May.
And you said the draft is completed still with the researcher. What was the research required? The sequestration, as I understand it, if it's sequestration, it's pretty straightforward.
There were 2 voluminous applications. You know, I had to apply my mind. I had to deliver quality judgments. So, you know, I had to spend time doing research and everything. So hence they took longer than expected.
And then my follow-up, my second question is that you said on page 17 of your application, and the judge president, Dawati, also referred to it, you said you were behind with my bond and rental leases or in arrears. What led to this? You told us earlier that you represent municipalities, and that to me is a very good, solid practice if you said you represent several municipalities. So what led to the financial
I think it's delay.
problem?
Delay in getting your what you call payment of invoices. You know, so it leaves a gap. So that is why I had to, you know, put my house on sale so that I can dispose of all the debts. So, you know, sometimes if you invoice, and then municipalities sometimes they don't pay. You know, So they just sit.
So those debts have not yet been settled, not yet. They're in the process of being settled. Am I correct?
No, some of them have been settled now. So I've settled some of them. So I'm just left with a few.
Thank you. Thank you, Judge Perez.
Commissioner, DP Zone.
Thank you, CJ. Sorry. Thank you, Chief Justice. Morning, Mr. Kwagwa.
Morning, Commissioner.
My question relates to page 11, the paginated number is number 11, but the printed number is number 7.
Page 11.
Yeah, 11, the handwritten one. Are you there?
Is it on the bigger bunker?
Yes, this document. Page 11.
Yes, page 11. I'm on page
Paragraph 6.5.
Oh, 6.5, yes.
Yes.
At the top there.
The CJ asked you about the judgment, and then you said that the reported judgment, you said that you asked your secretary to check if there are any reported
Oh, yes.
judgment, and then you said we have since discovered that there are about 9 to 12 judgments that are reported
Yes, correct.
on Safely. Is that correct?
Yes, that's correct.
But now, in paragraph 6.5 of the questionnaire, you said that there are none.
Okay, I think at the time of filling this form, I had not inquired from my assistant in Devon as to whether are there any reported judgments at Safri. So that is why I said none.
But
However, I discovered later that there were about 9 or 12. So, but at the time of completing the form, I did not inquire as to whether are there any reported judgments that are reported at Safri.
sure.
So that is why the answer is none.
But do you understand that it's something that you should have, before you completed the form, it's something that you should have investigated and then complete the form?
I understand it very well, yes.
So in that respect, the form that is before us is incomplete. Would you agree with me?
Well, you may say so, yes.
Okay, thank you. Thank you, CJ.
Commissioner Pillay.
Thank you, Chief Justice. Good morning, Mr. Gwagwa.
Morning, Commissioner.
As I understood your explanation, Mr. Gwagwa, as to why you haven't disclosed the application to suspend and the order granted by the High Court suspending you. The reason you didn't disclose that in your form is because of the way in which question 3 of section 4 of the form is formulated.
Yes.
You say that it's referring to present disciplinary proceedings.
That's how I understood it. Yes.
Right. Can I ask you to look at question 1 of section 4?
Question 1, section 4.
And that's you'll find at paginated page 17.
17. Yes, question 1.
So question 1 says, are there any circumstances, financial or otherwise, known to you which may cause you embarrassment in undertaking the office of a judge? Did you not think that an order suspending you from practice as an attorney was a relevant factor to disclose in section 1?
Not at all.
In question 1?
Not at all, according to my interpretation of this question.
And if you look at the last question in section 4, question 5.
Question 5.
Is there any other relevant matter which you should bring to the attention of the Commission?
Yes.
So you didn't think that an order of the High Court suspending you from practice is a matter which you ought to have brought to the attention of the Commission?
Not at all. You see, like I said, I made an example of, in a criminal court where you are the accused is asked about the previous convictions or any pending cases. See here, it does not come close to events that transpired 5 years ago. So it depends on my interpretation. So the only thing that I thought is about, oh, I'm in areas for this and that, then I had to bring it up, So I had to show honesty in that this is what I can remember. But anything other than that, unfortunately, I could not understand it in a past form, if I may say.
So an order of the court suspending you for professional misconduct that you don't see as relevant.
But the question did not say any suspension by LPC in the last 5 years. It does not say so. So now, how should one understand the questioning? It depends how you interpret the question. It just depends how you understand, your understanding, and then you answer accordingly. It's not a malice to understand it in a different way. But in any event, I did disclose it and explained that these are the events that transpired then.
And you disclosed it after it had been raised by the GCB.
Come again, Commissioner?
After it had been raised by the GCB.
Yes, I had to answer.
I'd like to take you to one of your judgments. It's the judgment of Man Energy Solutions Middle East.
Oh yeah,
Do you
that was
remember
the
that?
application for rescission.
It was an application to amend the summons.
For amendment of some, yes.
Yes. And what the applicant wanted to do was to include the words, the letters FZE,
Yes.
Free Zone Enterprise,
Yes, I remember.
at the end of the applicant's, of the claimant's, the plaintiff's name. Do you
Yes.
recall that?
Yes.
And the defense raised, the opposition raised to the application to amend was that it would change the nature of the legal entity before you.
Yes.
Because before that it was LLC, and if you add FZE to
Yes.
the end of it, it will change the nature of the legal enterprise.
Yes.
And so what you were actually dealing with was a substitution
Yes.
of plaintiffs rather than a pure application for leave to amend.
Yes.
Now, when you considered the application, you find that there is no prejudice to the defendant. And you don't at all deal with this central opposition, which was that in effect, what the plaintiff is looking for is a substitution of entities rather than an amendment of the summons in particulars of claim.
I think I did touch base on that issue, because the question was whether, if amendment is granted, is there any prejudice that will affect the change of the company as a whole? I think I did revisit that aspect.
You're correct, Mr. Gwagaba, you deal with prejudice. I'm putting a separate issue to you. I'm saying to you that what the opposition to the amendment was that in effect what the plaintiff was seeking was a substitution of entities. Because if you added FZE to an LLC, it became a different legal entity. And for that reason, they were opposing the amendment. That is not dealt with at all in your judgment.
That was the argument by the respondent, and I had to address all of that, because I think it is addressed in my judgment, that issue.
Not in my reading of your judgment, but I'll leave it there. Mr. Gwagwa, just a last issue. You'll know that on the 9th of August, 2025, the judiciary adopted its sexual harassment policy.
Yes.
Are you aware of that?
Yes, I'm aware.
And have you been through the sexual harassment policy?
I know about the sexual harassment document, and I'm quite conversant with it, but I haven't read the recent amendment, but I'm quite conversant with the previous one.
Sorry, was the previous?
With the previous act, which deals with sexual harassment.
I'm sorry, I'm not following you.
I'm quite conversant with the previous sexual harassment act that deals, the previous sexual harassment act. I'm quite conversant with it, but I haven't read the recent amendment act.
Which previous sexual harassment act are you referring to, Mr. Gwagwa?
The one that is existing currently.
Is that the new policy?
The previous policy that existed before.
Thank you, Mr. Gwagwa. Thank you, Chief Justice.
Commissioner Kotsa,
In the interest of time, I will forego my question.
you covered. Inkosi Nonkonyane.
Thank you, Chief Justice. Good morning to fellow commissioners. Good morning, Mr. Kwakwa.
Good morning, Commissioner.
My question actually is a follow-up to the question that was posed by the JP of the province initially around the allegations from Mr. Zet Mtenjwa.
Oh, yes.
Matendwa rather, sorry. I leave the portion she brought to your attention. Mr. Matendwa further alleges, that's why I'm inviting you for your comment,
Yes.
that you benefited from the 500,000 that was surreptitiously dispersed by Mr. Duze, accused number 8, to the attorneys, which means your firm of attorneys, I assume. But what troubles me, it says, based on the pending criminal prosecutions, Mr. Matendwa implores the JSC not to consider your candidature for appointment, as that would bring the name and stature of the judiciary into disrepute.
Yes.
I'm merely inviting your comment
Okay.
in that allegation.
All right. First and foremost, he says he opened up a case, a criminal case at Richards Bay, and then he put the case number there. I think there is a paragraph where he says Mr. Kwakwa was not arrested. It should have ended there. So there is no pending case against Mr. Kwakwa, that is myself. There is no investigation pending. I'm not attending any criminal court. I'm not being investigated. I am a free citizen, who aspires to live and make a living. So I think Mr. Matendwa is grieved or was grieved by the outcome of the recommendation that I made. So he wanted to find something, to hold me at ransom. I'm not attending court. I'm not being investigated. There's nothing pending for 4 years now. In fact, even in future, there's nothing. So the notion that I benefited from the amount that he alleges, he's just putting everything on the table just to derail and confuse the JSC so that there might be something, that the JSC must consider. There's nothing pending. So I'm not even under the concept innocent until proven guilty. There's nothing. So it's just I would say it's jealousy. It's, I would say so. So he just wants to derail, and confuse the JSC. And, that's what I can answer.
Thank you, CJ.
Commissioner Hassan.
Thank you, CJ. I want to follow up, Mr. Gwagwa, on these objections. Commissioner Hassan over here. The objection claims that you later appeared as a witness for one of the accused, I think it's a Mr. Mhlanga, in a CCMA dispute. Do you accept, Mr. Gwagwa, that this could create a perception of potential bias or perhaps even a conflict of interest? In hindsight, do you think it was appropriate for someone who was exercising quasi-judicial functions to go ahead and appear as a witness there?
Okay. See, ordinarily, if you preside over a hearing, any institution sometimes call you to confirm the contents of your recommendation. So that was basically for me to confirm the contents of my recommendation. It wasn't anything else but to confirm that I was the presiding officer, I recommended the sanction against whosoever it is. It's only basically on the procedure side as well as the substance. It's not beyond that.
Okay, and then the objection also says one more element that I think it's important for you to respond to.
Yes.
It says that you did chair a number of disciplinary hearings as part of the panel, and according to the objection, they were used, these disciplinary hearings were used as part of a pattern to target municipal employees who were whistleblowing corruption. So I'm interested to see how you respond to that first, and we also need to understand whether those hearings, or how did you ensure rather that those hearings complied with those natural principles of natural justice and how they were free from improper influence. Effectively, what we need to understand is, or let me allow you to respond first before I do the follow-up. Thank you.
All right. I have always subscribed to a notion of impartiality. Whenever I am appointed to preside over any hearing, I always exercise a notion of exercising fairness, without fear or favor. So I've been guided by the principles or ethics of maintaining the profession and the integrity of the profession. So I understand it very well what it means. So I've not deviated from it even today. So I understand how to be impartial. So the second question is about whether I was used to abuse or implement a notion of should I say, siding with the employer in whatever dirty work that they were doing. No. My principles are based on fairness. They are based on, fairness, if I may say. So I cannot be used otherwise. It's not me.
Final question, CJ. Apologies, it's part of that follow-up. Mr. Gwagwa, even where there was no misconduct that's been proven, do you acknowledge that proximity to allegations of municipal corruption could potentially erode public confidence in the judiciary? And how would you reassure the public that your conduct has consistently met that constitutional or even professional standards, especially given that you are requesting or applying to ultimately come to the bench?
Okay. Can you just repeat your question?
So how would you, well, firstly, do you acknowledge that the proximity to these allegations of municipal corruption, etc., could erode the public confidence in the judiciary? But we're also interested to know how you would reassure the public that your conduct has consistently met constitutional and professional standards.
I understand the principle of, the principle of fairness, maintaining the integrity as a judicial officer in whatever form. I understand what it means to be entrusted to preside either in the High Court or quasi-judicial inquiry. I understand the principle to uphold the law without fear or favor. I understand what it means to be trusted and what it means to maintain and apply those principles of fairness without fear or favor, without prejudice. I understand it very well, and the moment you are appointed, you are entrusted, so you should adhere to certain principles. The rules of natural justice must be adhered to, and must be seen to the public that indeed you can be trusted. I am against corruption. It is not part of my belief. So anyone who is entrusted or who is a public figure or entrusted with duties and functions that will be seen in the public, it should show signs of being trustworthy and apply those principles without fear or favor. So I understand very well. Thank you.
Thank you, Mr. Kwago. You're excused.
Oh, thank you.
Do I know further hands?
Okay, thank you.
Good morning, Mr. Hlatswayo. Good. Are you ready to begin the interview?
Yes, Chief Justice.
Thank you. You're an alumnus of the University of KwaZulu-Natal. Is it Durban Westville? Because I
Yes,
see Westville in brackets.
it used to be Westville, Durban Westville.
All right.
It is now KwaZulu-Natal University.
And you obtained BUris and LLB degrees from that university.
Yes, Chief Justice.
You're an attendee, well, you come from the ranks of the sidebar. You did your articles from 2000, then obtained them, built your way up until you started your own practice.
Yes, Chief Justice.
When was that? In 2007.
Yes, Chief Justice. Even though
Hlatswayo and Associates.
yes, but prior to that, I also practiced in partnership with another attorney.
At Bell and Associates.
Yes, Chief Justice.
There are a few other, well, you were involved with a few other law firms, I see. But you opened yours in 2007 and ran it until 2010.
Yes, that's correct, Chief Justice.
And during that period, you started acting as a magistrate.
Yes, I started acting in 2008 as a district magistrate, and I was appointed in 2010 as a magistrate.
Until 2020.
Until 2020, and in 2020, I was appointed
in the
as a
regional court.
In the regional court, after acting also for about 2 years prior.
I'm sorry, commissioners. I'm finding that quite distracting. Sorry. I didn't sleep much last night, so my nerves are frayed as it is. Thank you. So you say you became a regional magistrate from 2020?
Yes,
to
Justice.
date.
I've been a regional magistrate from 2020 until to date.
All right. And you have enjoyed 5 acting stints in the High Court?
Indeed.
As a judge?
I did. I had the privilege of acting for about 5 stints before the application. I have subsequently had the privilege to serve 2 terms, which ended now in September.
So how long has been your acting stint in all? In terms of, well, according to court terms?
All in all, if I'm not mistaken, Chief Justice, it is about 30 weeks.
30 weeks.
If I add in the 9 weeks that I've served after the application.
Have you had occasion to write judgments in the High Court?
I did.
You listed only 3.
I think I submitted 4 judgments.
Oh, I missed the other one. So you listed only the ones you consider more important.
Yes, indeed. I only provided the ones that I considered.
All right.
worthy to
And
be
I would imagine that during your long stint as a magistrate, you've sat in civil and criminal court and done your appeals and all that.
Yes, indeed. In the magistrates' court, I was honored when I came from the attorney's profession to be immediately assigned in the civil court in Devon. It is indeed a very busy civil court. So I was exposed to a lot of civil work there. I sat in that court and until obviously I was rotated to other divisions. Essentially, I've been exposed to all divisions in the lower court.
And in the High Court, have you been exposed to a wide range of work? Have you done appeals, sat in trial court,
Yes,
motion
yes,
court?
Chief Justice. I did indeed sit in both in civil courts and criminal courts, but mainly in the civil courts and mainly in Devon. It is only now that I spent some time in Pietermaritzburg. So I indeed sat a lot in Devon High Court.
And you consider yourself ready for senior appointment in the judiciary?
I think so. With my experience, Chief Justice, I think I am ready.
Well, most of the professional bodies who've commented on your candidature seem to agree with you, but there is one who went the other way. Is it? I think it's the Advocates for Transformation, who have registered a few concerns about your personality, I suppose, because they say you treated junior members of the bar down there aggressively, and that you were not open to persuasion on matters in respect of which you formed prima facie views, which implies that you go to court with a fixed mind, how things are going to go. What would you say to those charges?
Chief Justice, it is difficult to formulate an answer because it is not matter specific. It is indeed difficult, but my entire experience in the judiciary has taught me to exercise a measure of judicial temperament and ensure that I give the opportunities to both parties to put their cases forward and also consider their views. I may at times, of course, engage in order to limit the issues and determine what is indeed in dispute. However, that has not in any way resulted. I've not had an instance where my engagement with counsel has gone to the extent that it had led to a situation where one can describe it as being aggressive. So
My apologies, CJ. Can we ask the mic to come closer?
Oh.
I'm battling as well.
We're struggling to hear you.
I think he moved his
Okay.
head to the side.
Thank you. I was saying that in my history in the judiciary, I've tried hard to ensure that I give a fair opportunities to parties to present their side of the case and be heard. And whilst I may engage with counsel, at no point did this generate to it being unpleasant or aggressive. In fact, when I look at the others or the other law bodies, it seems to counter what is being contained there. So it's difficult for me to formulate an answer because there are no specific issues that are being referred to.
Yeah, I understand that. Well, I must put this one to you as well. They say you are reluctant to deal with urgent applications, and that if a litigant dares bring an application for leave to appeal against your decision, you take that personally. But again, no specific details are
Yes.
provided.
Again, the same answer, Chief Justice. Um, if I refuse an urgent application, it cannot be tantamount to refusal to deal with the application. If it is refused on the basis, or it is struck off on the basis of a want of urgency, or if I have considered it and determined that indeed a case has not been made out, it cannot be regarded as a refusal to deal with it. I don't think one can refuse to deal with a matter that is placed before him or her. Again, it is difficult to formulate an answer because there is no specific matter. I've also granted quite a lot of other leave to appeals. Again, it is a difficult situation for me to formulate an answer without a specific matter being referred to.
Thank you, Mr. Shrekman. Do you have questions for the candidate, JP?
Yes, thank you, CJ. Good morning, Mr. Hlachoy.
Good morning, JP.
Maybe it will help the commissioners if you try to, I know it's hard there, to sit still so that they don't lose hearing you, because now and again your voice fades. Perhaps let me start where the CJ has ended. Just to record that I have not received any complaint, nor the DJP, that you refused to deal with an urgent application.
Yes.
So this, because when I saw that comment, I had to ask him. And those are the people that deal with allocation of work. So we did not get any complaint. But just on the issue of the being not open to persuasion when you have formed a prima facie view, are you open to persuasion? And what is your understanding of a prima facie view?
Well, when you consider the papers before you, you obviously entitled to have an understanding that a particular matter is going in a particular direction, but of course you cannot arrive at a conclusion before hearing both parties. You need to give both parties a fair opportunity to present their arguments and consider their arguments holistically before forming a view on the matter. So indeed, JP, I am open to persuasion. Otherwise, if one is to simply go to court with a view and not being open to being persuaded, it is against the spirit of giving a fair hearing to parties.
Yes. And then on the one for the leave to appeal, that they say you take it personally, what is your understanding of the test applicable for the leave to appeal, and in particular, what officer when they are dealing with a leave to appeal application?
Well, my understanding is that Section 17 of the Uniform Rules outline what needs to be considered. In particular, the one needs to be satisfied that another court would come to a different conclusion. It is indeed a high bar to be achieved by the appellant. However, one needs to always be open to give parties an opportunity to proceed to another court, so that their case could be tested. Perhaps you may have overlooked certain aspects of the case, but only if on proper grounds it is shown that indeed another court will come to a different conclusion.
So when they persuade you in the application, do you get offended, especially when they tell you that you have aid in accepting that or not accepting that?
No, JP, not at all. As I've indicated earlier, I've dealt with quite a lot of leave to appeal. I've granted few that are deserving. There won't be a stage where one would be offended by it. It is a right that is enshrined in the Constitution for parties to exercise their right to appeal.
Yes, so you were referring to Section 17 of the Superior Courts Act, not
Yes.
Uniform Rules.
My apology.
Yes, no
Yes.
problem. All right, let's just come back to your acting stints in the High Court. How have you found the work in the division?
It was indeed enjoyable. I at the same time challenging. Even though my experience in the magistrates court, especially in the civil court, had equipped me to be able to deal with a challenging motion court and busy civil court matters. But the complexities of the high court matters meant that you had to rise up to the occasion. Also, the senior colleagues were of great help. It is indeed a pleasure that I served in the division under those circumstances, JP. Thank you.
Yes. And how many judgments totally from the High Court have you ascribed?
From my calculations, there are about 31 judgments for the 30 weeks that I've spent in the High Court. I'm talking about written judgments only.
And what was the longest time that you took to hand down a judgment?
I would say 2 months. I've not gone above 3 months.
Yes. And just on your regional court, there's always a perception that judges don't have too much work, and at times it comes from the magistracy. So you've been a district court, regional court, and acted in the High Court. What is your view about that comment?
It is misconstrued. Indeed, I mean the level of work that one has to do in the High Court demands that you do not have a specific time that you work, even after hours or weekends. You have to dedicate yourself if you want your work to be done properly and for you to be up to the challenge. There is extensive work in the High Court, and the complexity of it requires you to always be at a particular level and do your researches. So I wouldn't agree, even though there is quite a lot of work as well in the regional court, but I wouldn't agree that there is less work in the High Court. Yes,
and in the regional court, do you have parties, and how many do you have?
The last time I checked, JP, there were about seven parties. I must say that in the regional court, the circumstances or the conditions under which you operate dictates that you are always in court dealing with new trials, and most likely you're going to have challenges with those trials not being finalized for a variety of reasons. One witness is sick or multiple accused. So you try to deal with your cases on a continuous roll basis, but sometimes it is difficult, and the regional court directives say that you are allowed to at least at one time have 15, but last time I checked there were about 7, but those are easily disposable as well.
Yes, and one of the issues in the regional court, in KZN in particular, is the issue about the finalization rate of matters and the court hours. What is your average per month of your finalization rate, and what is the average of your court hours?
On average, I would say about 7 to 8 matters. Obviously, these are extremely serious matters because you're dealing with murders and robberies, and the evidence is long as well. It is similar to the High Court criminal trials at times. So, and when it comes to the hours, I would put an average to about 4 hours or 3:45 to 4 hours.
Yes. On the appeals, you've sat in both the full court and the full bench,
Yes, yes,
and I would imagine you have not scribed in a full court.
not yet. I didn't have the
Yes,
pleasure. Yes.
because that is the convention in our division. But you've scribed in the full bench.
Yes.
What have been the comments from the presiding judge of your judgments? What is the feedback that you have received?
Well, I've received good comments. At no point when I worked with senior colleagues, my judgment had to be redrafted. In most instances, it is a question of sorting out one or two errors, but other than that, the substance of the judgment was always agreed upon by senior judges, and they commended my writing style, and so that is it. Thank you, JP.
Yes. And just on some law issues, what, in your view, are the jurisdictional requirements for granting a winding up order?
Well, the winding up order can only be granted if a party against whom the order is being sought has committed acts of insolvency, and therefore there are other whole host of requirements that need to be met for a court to grant that order, including service of the of the application. And in our division, we require that an interim order be obtained first before a final order is granted.
And lastly, under what circumstances is an application for reconsideration brought before the judge?
Generally, it is done where a matter had been the application has been brought on ex parte basis, and therefore the other side has not had an opportunity to be heard. They have an opportunity within a certain period to bring an application for reconsideration.
Yes, thank you. Thank you, Chief Justice.
Premier?
No, also covered here.
Thank you, Premier. Commissioner Kotsa?
Thank you, CJ, and good morning, sir.
Morning, Commissioner.
I just want to perhaps clarify the extent to which you have dealt with criminal matters, criminal trials in the High Court. I see from your CV that you are a regional court magistrate.
Yes.
It seems mainly civil, but I then saw in your CV somewhere criminal. I just want to know perhaps the extent to which you've dealt with criminal matters in the High Court, also as a regional magistrate.
Commissioner, I've done 2 stints in the High Court criminal courts. Both of those stints, I was lucky, or maybe with dedication, I finalized both those, both whatever cases that were allocated to me within the specific period of time. So I have in-depth exposure in criminal matters, also supplemented by the regional court, where every day one is required to deal with those criminal matters.
So just to get back to the AFT KZN letter, they say they do not support your application and that they're of the view that you could benefit from further training and acting positions. I just wanted to ask whether you think that is a fair assessment. And I also wanted to know their note that says, unfortunately, you took an application for leave to appeal against a judgment somewhat personally. Do you know exactly which matter that is that they're referring to, and what could have possibly given them the sense that you took it personally?
As I indicated earlier to the Chief Justice and the JP, it's a bit difficult because there is no particular matter that has been referred to, and I would perhaps have taken the liberty of listening to the record. So I'm in the dark as to how they arrived at that conclusion. But as I've indicated earlier, and the GCB also has indicated this, that I have engaged counsel on a number of issues where, in an attempt, obviously, to get clarity on the issues. But that engagement, at no stage has it degenerated to such an extent that one would say that I was indeed taking a particular issue, or I was taking it personally. So it is difficult for me to proffer an answer. Thank you.
Thank you, CJ.
Professor Marumahai? Okay.
Thank you, CJ.
Oh, there's a follow-up, sorry. Commissioner Kane?
Sorry to interrupt you, Commissioner. Just on the question of appeals, sir, is the test whether the applicant for leave would succeed in the appeal? In other words, must you be persuaded that they would succeed, or must you be persuaded that they'd have a reasonable prospect of success?
The reasonable prospects of success is ingrained in the test on as to whether they will succeed. Obviously, one will have to find that what they've presented to you, they have reasonable prospects of success. But the recent amendment in terms of Section 17 takes the bar higher because it requires that one must be persuaded that another court would come to a different conclusion.
Thank you.
Prof?
Thank you, CJ. Good morning. I had a question that I wanted to ask you, but there's something that the JP asked you that I could not really grasp whether you are familiar with it or not, and I want to pick on it. I'm not sure, have you been able to deal with insolvency matters in that division?
Yes, I have. I've dealt with provisional sequestration, and I've dealt with final orders, yes.
Perhaps then my question would be fair. The question was, what are the jurisdictional factors for liquidation? And your answer appeared to me as if you are giving the jurisdictional factors for sequestration. What I want to understand is, under what basis would a person want to liquidate a company, and which particular act is applicable under those circumstances?
Well, okay, maybe I did not understand initially. One of those, obviously, is that that particular company is unable to pay its debt, and that a particular demand has been made, or a return of a nulla bona has occurred. So in my recollection, those are primarily the jurisdictional factors one has to consider.
And the applicable act?
That will be the Companies Act.
Oh, okay. Thank you very much, CJ.
JP Tlaletse?
Thank you, CJ. Mr. Hlatsoyo, in the annexure to the questionnaire, section 2 thereof, I think it's on page 18, paragraph 6. You indicate that your stint in the regional court that commenced in 2017, you gained valuable experience, and you indicate mostly in criminal cases. In the regional court, what I want to understand, do you have any load of civil cases that you deal with?
Yes, Commissioner, there are. I also sit in the civil court in the regional court.
Do you have a lot of cases to deal with? Because the increase in jurisdiction was to try and obviate the number of cases that are clogging the rolls in the high courts.
Yes.
Do the practitioners make use of that advantage in your area, or they still go to the high court?
What I've found is that they are not so many as compared to the high court. Previously, before the civil jurisdiction was extended to all the regional court, it was assigned specifically to certain seats, certain regional seats. Under those circumstances, the rolls were quite high, and therefore a decision was made to just extend it to all the regional court seats. But I have found that there are not so many. You have quite a lot of divorces, you have quite a lot of applications, Minister of Police matters. But as compared to the High Court, I do not know. I mean, they are not as many as compared to the High Court. I do not know the particular reason why that is the case, but perhaps maybe because some of the courts may not really have the expertise. I do not know.
Yes. So mostly cases which would have been held in the regional court are taken to the High Court.
I've seen a lot in the high court that could easily have been determined in the regional court.
So would you say we need to build a lot of capacity in the regional court so that which are said to be closer to the public, that all these cases can be dealt with at that level rather than cloaking the high courts?
I agree with that, Commissioner, because as it stands now in my court, I sit 4 days 3 days in criminal court and 2 days in the civil court. So I have to alternate in both. So if there is capacity, it will definitely elevate a lot of work that is finding itself in the High Court.
Yes, I see. Thank you, Chief Justice. Thank you, Mr. Hlatsoyo.
Thank you, CJ. Good morning, Mr. Hlatsoyo.
Morning, Commissioner.
Just one from myself. Recently, the court has declared that paternity and maternity leave will be equal. So I always ask myself, what is the source of this power that the court has? If it is a discretion that the court has, what is the source of that discretion? Thank you.
It is difficult to answer. I've only read through the news. I haven't really read the question. I mean, the decision that was reached in the Constitutional Court. But I will imagine that the equality principle or principle in the Constitution will apply. But also, the basic conditions of employment would also find find applications. So that is it that I can imagine. I haven't really read the judgment itself, Commissioner.
But the decision that the court always take to either set aside the decision of the legislature or the executive, sometimes I take it as an interference on the other arm of the state. What is your take on that?
There is a fine balance that has to be achieved in determining whether the decision of the legislature should be set aside or yes. And obviously, the Constitutional Court has pronounced on the test that needs to be followed, in particular where the decision or the legislation that had been enacted does not serve the particular purpose that it was enacted for. The Constitutional Court has pronounced on how one can then arrive at a decision of setting aside that legislation decision.
Thank you, Mr. Kaga. Thank you, CJ.
Dr. Justice, could I just follow up on this? I'm a little bit both confused and concerned. Thank you. Mr. Tlatwa, it's just a question around the answer you've just been discussing now. Where does the power of a court to set aside legislation come from?
It comes from the Constitution, Commissioner.
Yes, and on what grounds can a court set aside legislation?
Well, where the legislation doesn't achieve the purpose that it was set out to be. That is my understanding, Commissioner. Where it is unreasonable and does not achieve the object and the purpose that it is set out to be, and it is not consistent with the Constitution.
All right, so if legislation infringes a right in the Bill of Rights, is that one of the grounds?
Yes, if it is inconsistent with the Constitution, it is definitely one of the grounds.
Yes, and are you familiar with the role of Section 36 of the Constitution?
Yes, Commissioner, it relates to the limitation of those rights.
What is the role of that section in an assessment of whether legislation violates a right in the Bill of Rights?
If it is shown that the legislation that the infringement of those rights is justifiable in an open democracy, one would be justified in limiting those rights.
All right, maybe I should just suggest that you brush up on this part of the law.
Yes.
Thank you.
I would appreciate it.
Thank you.
Thank you very much, CJ. Is it still morning?
Morning.
Yes, good morning, Mr. Tlatwa. How are you?
I'm good under the circumstances, Minister.
That's under the circumstances. Okay. Mr. Tlatwa, I see, I'm following with what JP raised about your work as a magistrate and having acted at the High Court as well. I take that because magistrates or regional courts are said to be closer to where the communities are and giving access to justice to communities. Now, my question relates to you coming from KwaZulu-Natal as one of the provinces that is vast, and also because we have this legacy of apartheid in terms of our infrastructure, but also in services. In your view, how do you see the way we are structured being able to assist in access to justice, and whether there are mechanisms that we should be able to put in place to assist to ensure that communities don't travel long distances to access a court, especially noting that you've dealt with quite the most vulnerable in our communities, women and those that are senior citizens sometimes. Do you think that the way we are, where our courts are, but also from the point of our country's structure, are we able to say that we are giving that access to justice to the most vulnerable? Your views on that?
Yes, Minister, well, access to justice is crucial for the rule of law. In fact, my view is that sometimes it is important to take justice to the people. This may also involve setting up courts where people are, and I do not see any reason why presiding officers would quarrel against that, because it allows access to justice, and members of the community from the most vulnerable and the people who do not have funds to travel to various courts, they will have an opportunity to state their case closer to where they are. That is one of the measures that can be put into place.
Maybe as a follow-up, Mr. Hlatshoyo, having been even a regional magistrate, are you able to share innovative ways that at that level you've been able to assist in ensuring practically how to support those communities? I'm not so sure which region. I see you were a regional magistrate.
Yes.
Which region particularly?
I'm in Verulam, Minister.
Or in Verulam?
Yes.
Okay. So how do we deal with such? I know it's almost semi-urban, better compared to your other areas in Zululand and your Newcastle areas. But how do we ensure, what are creative ways that we've been able to ensure? Because these are the people, majority of them uneducated in terms of the legal framework, but yes, coming to your courts, what have you been able to deal with?
Well, as I've mentioned, Minister, in most instances, when we sit in these courts, you ready to start at 9 o'clock, and you informed that the witnesses are traveling from far. They're traveling from Ndwedwe and other areas which are outlying in rural areas. Sometimes you inform that they do not have money to travel, which is precisely the reason why it is important to take justice to those communities. When it comes to Verulam and Ndwedwe, they are not far apart. It is a question of resources being available to take the court to the people, so that cases that are coming from that court can be dealt there, and people in the area can see that justice is being done, and they can also attend themselves. That is all that I can suggest, that I can think of at the moment.
Thank you very much.
Commissioner Mangen?
Thank you, Chief Justice. Good morning, Mr. Hlatshoyo.
Good morning, Commissioner.
Amongst the judgments that you gave us, there is a judgment dealing with evictions, where friends loaned money to each other.
Yes, yes.
And towards the end of that judgment, you made reference to the provisions of National Credit Act.
Yes, Commissioner.
You recall that judgment?
I do recall it, Commissioner.
And as part of your reasoning, you arrived at a conclusion that there was a contravention of the National Credit Act in a situation wherein people who are friends and are loaning money to each other, what the creditor was required to register with the National Credit, was required to register as a credit provider. Is that what you found?
No, Commissioner. I did not find that there was a contravention of the National Credit Act.
Yeah.
Quite to the contrary.
You
I found that it is not applicable because my understanding of the applicability of the National Credit Act, it must be an arm's length agreement between the parties. It was that reason that I found that the National Credit Act was not applicable.
Was not applicable.
Thank you.
Okay. No, I may have read it wrong, because that's how I understand it. That the arm's length transaction is one of the requirements.
Yes.
In the absence of that, then there was no need for the credit provider to register.
I found that that it was not applicable because of that in particular.
Thank you so much. Thanks, CJ.
Thank you, Commissioner. There does not appear to be any more questions for you, Mr. Hlachwayo. Unless there's anything you wish to raise with us, you are free to go. Thank you for making yourself available.
Thank you. I appreciate the opportunity. Thank you.
Thank you. Commissioners, are we going to take a tea adjournment or press on until lunch? All right, 10 minutes until we'll come back at. Yeah, we have to. We have to finish by 4:30. I don't know how that's going to be possible at the rate we're going. All right. You have 2 degrees, a BA and an LLB from the University of KwaZulu-Natal.
That's correct, Jane.
What were your majors in your first degree?
I beg your pardon?
What were your majors in your first degree?
Political science and English.
Right. You joined the Pietermaritzburg Bar in 2007.
That's correct.
But before that, you had worked for a number of years at the Commission
of Land
on
Rights.
the Restitution of Land Rights. What did you do there?
I initially joined the commission as an admin officer.
I'm sorry, just speak into your mic. I'm struggling to hear you.
Sorry, I initially joined the commission as an administration officer, where I assisted with negotiation support. And thereafter, I became a project coordinator, where I then researched and helped settle claims. That meant doing the entire investigation, going out to the community, verifying the claimants, the beneficiaries, and then making a submission to the commissioner and the minister to then settle those claims.
I imagine that you appear frequently in the Land Claims Court.
Not as often
Not
as I would love
necessarily.
to, but I have appeared in the court.
All right. So what kind of practice do you run?
My practice has now become a more civil-orientated practice, but when I first started practice at the bar in Pietermaritzburg, I was not from Pietermaritzburg, so I was not familiar with most of the law firms. And in terms of the taxi cab rule, I had to take what work was given to me. I did a lot of criminal work in terms of being briefed by the Legal Aid Board for about the first 5 years of my practice, with a few civil matters. And then after, I got more work in terms of personal liability claims for and against the RAF. And then I got to work some liquidation, some matrimonial law matters, some labor court matters, as well as some land claims matters.
When did you start acting in the High Court?
In January 2024.
And when was your last stint?
I just came out of a stint now. I did do recess duty, and I had a stint in the last session.
Okay. And how long have you acted as a judge in all?
In terms of my calculation, in terms of my application, there were 37 weeks at that time. Subsequently, I've done a further session and recess duty. Together with the voluntary acting, you're looking at 43 weeks in total.
And have you had a chance to write any judgments during that time?
Yes, I did. In terms of the 3 judgments that I've submitted, I've written a further 46 judgments, out of which 36 were delivered. In terms of the other 9 judgments, they were ex tempore judgments, which I have delivered immediately after the matter, after considering the facts on the same day. Those are the judgments that I've written.
All right. And you cleared your desk. Do you have any outstanding work in the division?
I beg your pardon, Chief Justice?
Did you leave with your desk clean? Any outstanding reserve judgment, old reserve judgments, that is?
No. So I was hoping to have achieved the same before I had filled in my application. But unfortunately, on Friday, I heard an application for leave to appeal. And although I had a prima facie view of what I was going to do, I had to reserve the judgment because there were other factors that I needed to consider. So based on what happened on Friday, I do have one outstanding judgment which I would prepare.
All right. Judge President Boyot.
Thank you, CJ. Good morning, Advocate Nilgin.
Good morning, JP.
Just on what, follow up from what the CJ has asked you about reserve judgments, what is the longest period that you've taken to hand down a judgment?
I think it was just over the 3-month period. That was as long as I've taken.
Did you explain yourself to myself or the DJP as required by the Judicial Code that when you're going to take longer, you have to explain yourself, or you were not aware?
No, I was not aware, but I think it was 1 or 2 days, so I wasn't sure of that, JP.
Yes. Are you aware with the Judicial Code?
Yes, I am.
Yes, and the norms and standards?
Yes, I am.
Yes.
I had to familiarize myself with that.
Yes. All right. And have you done an acting stint in Devon? I just don't recall if you have.
Yes, I did. It was when Judge Sigubin was called to the Constitutional Court. I was called in and I did an acting stint in Durban.
And between the Maritzburg and the Devon High Court, is there any difference? It's one division, but is there any difference in terms of workload or anything else?
I didn't find a difference. There is a lot of work at both divisions. At both courts. It was just a matter of the traveling, but that was manageable. So I'm quite comfortable in both environments.
And how have you found the judges in the division whilst you were acting?
Very collegial, very helpful. Everyone puts in a lot of work, a lot of effort, and they have an open door policy. The attitude is that we need to deliver justice. And if anyone is stuck, especially acting judges, everyone has the attitude that please come and find out so that we do the right thing. And I found that very encouraging, very supportive, which is good. It assists to calm a person down to ensure that we can deliver justice at the end of the day.
Yes. And in your form, you say you are a member of the KwaZulu-Natal Legislature Interfaith Symposium Planning Committee. So my understanding is that you are not a member of the legislature.
Yes,
But of that committee.
that's correct. This is a public participation committee where the legislature reaches out to the community. And because of my involvement in the faith sector, at that time I was a member of the South African Hindu Mahasabha, which I'm the president of now. I was delegated to be on that committee for interfaith dialogue and to ensure that the faith sector gives its input into the legislature.
Yes. So just on that presidency, you've taken over from the late Mr. Trikamji.
That's correct. Yeah, it was. Sorry, JP. Yes.
Yes.
Yes. It was sad that I had to do this. It was unexpected, but the organization felt that I would be most suited to take over, and then elected me as the president of the South African Hindu Mahasabha. Subsequently, we've had a BGM, and I was re-elected into that position.
So if you get recommended and eventually appointed, will your community not suffer because Mr. Trikamji has just passed away and you've just assumed that responsibility? What is your view on that?
I believe with my leadership style, which is slightly different from that of the late Ashwin Trikamji, we have something like 23 subcommittees that deal with the different responsibilities of the South African Hindu Mahasabha. And I've ensured that all of these subcommittees, the chairpersons, deal with whatever needs to be delegated to them, and all I do is coordinate. So I'm not going to be, as much as I respected the late Ashwin Trikamji, I'm not going to be in the same position that he was in, because I want people to see that there are more than one person in charge of the Mahasabha. And it's not a one-man band. There's an entire team of people that are doing dedicated work for the community on a voluntary basis. So I don't think it will impact if I'm appointed, because I think I've been able to strike a balance. I've been able to balance my community involvement with my practice, and I have a varied involvement in the community because I believe that is a sector that I need to add value to. And when people ask me what I do for fun, that is what I do for fun. I actually enjoy serving the community.
Yes. And the BLA says they do not support you, but I'm not sure of the actual reason. I think they said lack of experience. I'm not sure. What is your comment on that?
I was a bit surprised, but when I look at it, it's simply we do not support this appointment as the candidate appears not to have acquired enough acting experience in the High Court. We do not support his appointment. So my understanding of the norms were that one should have at least 24 weeks of acting. I have acted for more than 43 weeks. I think I've acquitted myself in a dignified manner. I've been impartial. I've conducted myself with what I would consider judicial temperament. So I respectfully disagree with the BLA. If one looks at the comments made by AFT and the GCB, it's contrary to the comments made by BLA. But each organization is allowed to have their view. Unfortunately, they didn't substantiate why they felt this way. It's a two-liner on their comments.
Yes, and in addition to your acting stints, you appear regularly in the motion courts and also in the trial courts, and you conduct
That's
trials.
correct.
Yes.
So, I mean, I've been in the High Court. I've appeared in both criminal and civil matters, in trials, in opposed motions, and just ordinary motion court briefs. So it's unfortunate that I don't have actual reasons why the BLA went in that direction. But I think the proof is in the number of judgments that I've given, the number of matters I've heard, as well as my conduct. The advocates that appear in court have given a different view of my conduct and my suitability to be appointed as a High Court judge.
Yes. And perhaps the one area I think that you have not had sufficient exposure is the criminal courts, because we've always allocated you civil work. Because in the division, the view is the sitting judges must do the criminal work, because people in the criminal courts give the acting judges a runaround when it comes to the matters proceeding. So for that reason, I think you've had one stint in
Yes, I have.
5 weeks in the criminal courts. So with that, that is an area there where I want to ask you 1 or 2 questions. What is a test for an application in terms of section 174?
Well, was a prima facie case made out which the accused needs to answer or not? I just came out of a trial now where I refused 3 applications in terms of 174 because I felt a prima facie case was made out which the accused had to meet. They then subsequently closed their case, and I then acquitted the 3 accused because the highest standard of beyond reasonable doubt was not met by the evidence that was presented before the court. So there are 2 different standards that need to apply. And my understanding of 174, it is something that I used frequently during the 5 years that I did a lot of work for the Legal Aid Board. And it's a technical matter. One obviously, as a practitioner, used that to test where the court was going, but the court has obviously seen that from practitioners and has reserved the reasons for being delivered at the end of the judgment. So I think I'm comfortable with applying the principles of prima facie case for a 174 application.
Yes. And in a criminal trial, let's say you have 3 accused. The one accused pleads not guilty, the second one pleads guilty, and the third one pleads not guilty. What will happen in that case?
We'll look at a separation and then deal with the guilty plea separately. And then the other 2 will then go on trial.
Yes. And maybe finally, you are a humble, probably nice person, and I have a reason why I preface it that way. Now, in a full bench, when you go into court, and if the judge, the senior judge presiding, gives an extempore judgment, and then it comes to the last part where they say, I propose the following order, and you don't agree, what would you do?
Well, because what normally happens is that both the judges will consider the appeal and discuss the appeal before we go into court, and we'll have an idea of where we are going. I did have a scenario where a senior judge, a very senior judge, had a different view from the one that I had, and was quite adamant about his view. I was able to sit with him and take him through the law as I understood it and the case law regarding the issue that he had raised. And eventually he told me, well, okay, you do the extempore judgment. So I think I've been able to deal with that in an amicable manner, also in a respectful manner, respecting senior judges, but also to stand my ground when I differed from a senior judge, especially in light of me being an acting judge. And in that particular matter, the senior judge then considered that I was on the right track and asked me to do the extemp judgment, which I subsequently did. If a scenario had to arise where we did not agree and the judge goes ahead and gives an extemp judgment, which I don't agree with, I will stand my ground. And I think that's something that we must pride ourselves here in South Africa, that judges are independent. We are not subservient to anyone but the Constitution. And we must put our views substantiated with law on the table in our judgments, so that even if it's a dissenting judgment, we must do so without any fear or favor.
So what would you do? Like the court is sitting, and he or she has gone through the facts and the reasons, and will you tell him or her, or will you get the court to adjourn? What will you do?
We'll have to adjourn because there are two different views, especially where there's two judges sitting, and get a third judge to look at the facts as well, and then bring in the third judge to give the deciding outcome of the appeal.
Thank you. Thank you, Chief Justice.
Thank you, JP. Premier?
Well, thank you, Chief Justice. Good day, Mr. Nerken.
Thank you.
How are you?
I'm good, Premier. How are you?
No, I'm okay. I just have one question for you with regard to the role of the court in educating communities to understand how courts work and their role to make the courts work easy. Is there any role of the courts which is as such?
Not directly, but you have a scenario even in the High Court where you have lay people who come in unrepresented, and then you exercise your discretion in giving them advice on procedure, but not giving them legal advice. I have not seen any program where the judiciary goes out and educates people on what needs to happen in terms of the law and legal processes that need to be followed. So I'm not familiar with that.
Thank you.
JP Tlanidze?
Thank you. Are you a member of a political party?
Yes, I am.
Are you an office bearer?
No, I'm not.
What do you intend doing, because we don't have judiciary of national unity?
Yes. I will reluctantly have to, if I'm appointed, I will have to resign in terms of the code of conduct for judges. It is something that I'll have to do.
Is it something that, I just missed your last word, you say it is something that you have to?
I have to do.
I see. Do you think there needs to be a cleansing period where you stay outside so that that period can go, then you can participate in the judiciary? Is there any need for that?
JP, I think I've demonstrated in my judgments that I'm impartial. I've had scenarios where municipalities that are run by the ANC have been taken to task, and I have found against them. I have a scenario, for example, with the Msunduzi municipality where I found for them and against them. So I've exercised myself as a judicial officer, as an officer of the court, showing total impartiality.
So no need for a cooling off period. Thank you.
For me personally, I don't think so.
Yeah, thank
you. Professor Marumachai?
Thank you very much, CJ. Good afternoon. Yeah, on this
Good
side.
afternoon.
I had an occasion to read one of your judgments that appear on page 29 of your paginated to page 29 of your questionnaire. I mean, of your bundle of documents. It is Tokosise Nyembe Zikubu versus Absa Bank.
Yes.
Remember that case?
Yes, I do.
And that is the case that dealt with the rescission of judgment.
That's correct. When
I read that judgment, I think the the applicant relied on Uniform Rule 42. And what appears from your judgment also, it seems like they also relied on the common law rescission. Usually, those two things are relied on in the alternative. In other words, you start first by the uniform rule. If that doesn't work, then you can revert to the common law. But I'm particularly concerned about what is stated in paragraph 37 of that judgment. Because in paragraph 36, you seem to provide a sense of what Rule 42 says. Then you provide a sense of the common law. What is not clear to me is, in what you state there, are you saying that is a test for the common law rescission? Because in that paragraph, it seems to me that you are talking about the setting aside of the judgment. And as I understand it, the judgment is about rescission. So I was not quite clear as to what is the actual test for rescission under the common law. Perhaps my direct question to you is, forget about section 42 for a minute. Let's just focus on the common law. What is the test of common law rescission? What is it that the party must prove in order to succeed in as far as the common law of rescission is concerned?
So,
Oh, I beg your pardon. It is in paragraph 21. Paragraph 21 of the judgment.
sorry, please say that again.
I was saying paragraph 21 of the judgment.
So, if one looks at paragraph 21, here I deal with the grounds of fraud specifically because that is the common law ground that the applicant, who was a lay applicant, unrepresented, used. So I only dealt with what was required for rescission in terms of the common law on fraud. That is how this judgment was dealt with. So what has happened here is that you had a litigant who tried to do different things. Although he brought a rescission application, in actual fact, he was bringing an appeal against the judgment. And what we were dealing with was res judicata. So that is why this judgment and the law that I dealt with specifically was common law grounds, which specifically dealt with fraud.
Okay, I'm confused. Was this an appeal to the full
was
court?
not
I mean, the full bench?
No, it was not an appeal, and that is why I'm saying when one reads my judgment, you will see that in actual fact, the applicant here tried to bring an appeal against the judgment, but couched it in the form of a rescission application. So even his arguments were more of an appeal, saying that the judge had made a mistake, rather than focusing on these in terms of what was the requirements in terms of fraud on the common law, and in terms of the grounds for rescission in terms of Rule 42, 1A and 1B.
Okay, I get that part, but
Okay.
the point is it was not an appeal.
Yes.
So
it's
what I
not.
want to get from you is, what is the test for common law rescission?
Okay. So was there an error that was made by the court?
Is that the test?
That's my understanding of the test in terms of common law.
All right,
But
no,
as I
will-
said, there are
I will-
different
I will-
aspects of common
I
law.
will leave it there, but I think you should check on that aspect because it's really important for decisions.
Thank you.
Thank you, CJ.
Thank you, CJ, and good day, Advocate Niven.
Good day, Commissioner.
Okay. I see you have a lot of experience in land claims matters, and surely mediation is part of the thing that you do a lot when you were there. Mine is just a comment. I just want to find from you, you have done a lot of land claims matters and also litigation, taking into consideration that litigation is very confrontational. And now that there's a move that we do mediation before matters go to court. In your view, how do you see the two? I mean, because mediation is voluntary. In civil matters, what is your view in doing that mediation? Is it likely to delay the trials and the matters for claimants, or what is your view?
Personally, I would like to see matters going through mediation for several reasons. One being that the roles are quite clogged. It might actually help the parties to arrive at a decision much earlier. The concern with mediation, though, is that it is generally expensive because the parties will then have to foot the bill for the mediator. But I think that mediation should be tried as an attempt to resolve the conflict before the litigants get before a court. It might be expeditious, it might not yield the results that are required, but I do believe that mediation should be tried as an option.
Thank you, CJ.
DP's want?
Thank you, Chief Justice. Good afternoon, Mr. Nepagin. I'm here. Yeah. I've got two questions for you. The one, as at the 11th of June, when you signed the questionnaire, you didn't have any reported judgment. I just want to find out why, and then it will seem that you had acted for 37 weeks. And in that 37 weeks, you couldn't find a judgment that you could mark reportable.
Yes.
Okay. Is it because of the nature of the cases that were allocated to you, or is it?
That's correct. In terms of the cases that were allocated to me, quite a few of them were personal injury matters in terms of the RAF. Those were resolved quite expeditiously. Yes. But in terms of the matters that I dealt with, I relied on precedents. They were not cutting edge where I interpreted any of the matters differently. Even the matter that I put in here as my third case, I didn't think it was worthy of being marked reportable. So I don't know if I'm being too critical of myself, but I think if there's something where I am influencing the way the law needs to be interpreted or interpreted differently, then I would mark it reportable. But I'm of the view that the matters that I've dealt with and the manner in which I've dealt with them have not changed the law in any way.
Okay, fair enough. Then my question to you relates to your experience as project coordinator or administrative officer in the Commission on the Restitution of the Land Rights. There's been a development which is somehow, to me, I think that which has caused me a great deal of anxiety and concern, and it is the following. Now, the majority of claims have been kicked out on the basis that the claims were submitted as a community claim and the community failed to prove that it was a community claim. And my concern arises from the fact that the community that would want to lodge a claim that will come to the office would be assisted by the officials of the commission in completing the claim forms. And but somewhere along the line, when they want to change the claim from being one of a community claim to individual claim, that has been prevented. I'm not sure what has been your experience in the Land Claims Commission with regard to the characterization of the claim as a community claim and changing of a claim from being a community claim.
So, based on my experience,
Yes.
which was obviously before I came to the bar, and we're looking at 1999 to around 2005. When I got to the commission, we had that first cutoff date in terms of the Restitution of Land Rights Act. for the lodgement of claims. And many claims on that last weekend before we closed, the Land Claims Commission was flooded with claims which were accepted, which were received and thereafter processed. When I say accepted, in other words, the forms were accepted and thereafter a process was followed in terms of trying to establish what type of claims they were. So it was an attempt to assist the community claimants to get the claims in. What we found, KZN specifically, I can't speak about the other provinces, is that sometimes an Nkosi or a traditional leader or someone who purports to be a leader of a community would put in a claim, but not give you the background justifying how it is a community. Or sometimes an individual put in a claim saying that they lived in a particular area, and you would find that in actual fact, that person was a part of a community, and the intention was for it to be a community claim. And that can only be established after an investigation is done. So once a claim is handed over to a project officer or a project coordinator, they then had to go in and then do that research to establish what was actually being claimed. Because sometimes people knew areas by the traditional names, not by what the geographical names or the accepted registered property names are. And you had to then go back and establish what was the extent of that claim, for example. And did it incorporate other community claims? Because sometimes you had different people acting independently, lodging a claim because their families lived in a particular area, either part of a community or sometimes in isolation. And you'd find that there were overlaps. So that is why there is this ambiguity between community claims and individual claims, specifically in the rural area.
Okay, thank you. Yeah, it's something that I think that needs to be addressed because I think that it's unfair to the claimants. But
I agree with you. I also have a personal grievance with the way the Restitution Act has been drafted. Because in a situation where urban claimants have put in a claim for a registered property, the claimant is still defined as the person who lodged the claim. So if you have siblings who ought to have benefited from that estate, they excluded. They only realized that the sibling who put in the claim was only acting on their individual capacity and not on behalf of the entire family. So there is room for maybe an amendment to the Restitution Act to actually deal with these issues that we are grappling with here today.
Okay, thank you.
Commissioner Hassan?
Sorry, Chief Justice, I got excited because it's land, but...
Well, she raised her hand for a follow-up before you. Oh, it's not? Okay, go right ahead, Commissioner.
Yes, all right, thank you, Chief Justice. You see, Advocate, sorry, just give me your name again. Nigen. Yes, Nigen, yes, thank you. This issue around the community claims has its source in the Restitution Act itself, in the definition of community, which the courts have grappled with since the judgment of Judge Moseneke, I think it was Khotgelegen. And what has happened is that the community has become narrower and narrower through jurisprudential devices, right? And that is why these days you hardly find a claim qualifying as a community claim. And the last of these cases was that case of Mhlanganisweni. Now, landowners like this. They like causing the division by objecting to the character of the claim as a community, which questions the people behind the claim and says, you are not a community. Which for me is ahistorical because it ignores the impact of settler occupation on communal identity. Whereas land claims are meant to resolve settler occupation. And the problem with settler occupation was that it disrupted the communal character of tribal societies. So now you are asking people in 2025 to reconstitute themselves as they were in 1913, when the very point of 1913 was to cause internal instability. Now, when you say you are proposing an amendment, what is the amendment that you have in mind that will solve the problem of the settler instability to communities?
We are going on I think an area that we both appreciate. I think you have done more research than I have, and it's an area that I've worked in. 1913 is most definitely a stumbling block in terms of the Restitution Act, especially since you've got title deeds that go back into the early 1800s. And my view is that we need to re-look at the 1913 Native Land Act as being the marker for the start of classification of community claims, because many of the communities get bowled out using that date in particular, because then the landowners simply say that, well, we have a title deed that pre-existed the 1913 or your requirement. So it's the community existed well before. I agree with you. I myself have not formulated what the change should be, but this is something that we have to come to terms with. Otherwise, we're going to constantly be revisiting communities that are going to be excluded because of the narrow interpretation of the Act and the way it is structured. And I think the amendment that was passed and then suspended went a little way further, but it didn't address the 1913 elephant in the room, and that needs to be set aside. That's my view.
Yes. And you see, again, I mean, the problem with 1913 is that they succeeded, the landowners, to constitutionalize it. So it's in Section 25 itself. So if we were to remove, and I agree with you that 1913 is in fact the primary problem with land reform, that will mean we must remove it from Section 25 itself. Do you agree with that?
Yeah, that's going to be a challenge. We're going to have to do a lot more work and get a lot more consensus as a nation. But I think it has to be done. Effort has to be put in there.
Sorry, Chief Justice. Then the last part, assuming that we cannot remove.
I suspect this is a conversation you should have with
All right, thank you.
Mr.
I'm
Nibrand
not pursuing.
offline, not here.
I think that the passion for land rights, and specifically our community, is important. But I agree with you, Chief Justice, that this is a conversation we should have about innovative ways to resolve a major issue in our nation.
Indeed. Commissioner Hassan?
Thank you very much, CJ. Maybe just before I start, it is wonderful to see candidates interview at the JSC who are so passionate about land and transformative restitution. So it is, I agree, a question for later, but it is interesting and wonderful to see that kind of thinking is happening, even beyond just some of those discussions that are happening in the media. Advocate, my question is a little bit different. You spent decades building cases from the bar. And so I'm interested, and you can decide in 2 minutes or however long. Tell us 3 advocacy habits that you'll carry with you should you be appointed to the bench that will improve justice in such a high volume court.
I think I'll focus on one. It's very important when you get a brief, you isolate what the legal issue is that needs to be focused on for your client in the matter. When I get the cases allocated to me, whether it's motion court or a trial, I look at what the areas are. I formulate a prima facie view of how to expeditiously deal with the matter. Generally, when counsel comes to see me, I would give them my prima facie view, and that has more times than not resulted in a consent order being granted. Now, the expertise or my personal character trait that I would bring in is to focus on specifically what needs to be resolved, cut out all the what I would consider peripheral issues, and deal specifically with the matter at hand. I think I have that ability. I've demonstrated that. Sometimes the attorneys have reluctantly not given me work because I don't flower what needs to be given and drag out matters. But that's just the nature of who I am, and that is something that I will bring to the bench if I'm appointed. Also, in terms of dealing with people who are indigent or less fortunate or may not be able to afford the fancy law firms or attorneys or counsel to defend them, I've also had a passion to try and do as much as I can at a minimal cost. In terms of what happens in court, you would see up to now, we still have a scenario where certain people would pitch up, counsel, senior counsel, junior, a whole lot of attorneys and bundles of documents even for their opponents, where the opponent is just a single litigant on the other side, maybe an advocate or an attorney, and sometimes maybe not as well prepared as he or she should be because of the lack of resources. So I think I display a matter of compassion without obviously prolonging a matter, but trying to ensure that the litigant's case is put before the court in the most effective manner without discounting the fact that there is a lack of resources. So that is something else that I'll bring to the judiciary if I'm appointed.
And then last follow-up, is there an example that you could maybe cite from your acting stints in which you applied exactly what you've just unpacked for us?
If one looks at the matter that we were referred to earlier, the Sukubu matter, there, Mr. Sukubu, unfortunately, he has tried various manners in which to try and get his property to remain his in the way he's challenged Absa Bank. And sometimes very rude. Sometimes I know that he has reported different judges that have dealt with the matter previously. And I was able to calm him down and allow him to present his case, much to the frustration of the representatives of Absa Bank. And although I found against him, I haven't seen or heard of a report against me and the way I conducted the matter. I do know that he has taken the matter to the Supreme Court of Appeal for leave to appeal, and that was turned down. And I do know that he has now tried to bring an application for leave to appeal to the Constitutional Court. But I think what's important there is that the manner in which I've dealt with him was to allow him the freedom to put his case before the court. I indulged him without prejudicing his rights, although I found against him.
Thank you, CJ. I'm comfortable.
We've reached the end of your interview.
Sorry, CJ.
Oh, yes, JB?
Yes, thank you. May I just follow up on just one issue? On the question asked by Commissioner Moromokhai on the rescission of judgment, and I want to refer you to paragraph 23 of that judgment. Yes, so you say there, it is clear that the applicant was present in court for the hearing of his matter on the 31st January 2022. He participated in the trial and made submissions to the court. There is no evidence that this matter was heard in his absence. Are you there?
Yes, I am.
Yes. So if that litigant was not present when the matter was heard, what would that litigant have to prove for the granting of a rescission?
Well, in that specific scenario, well, if the judgment was granted erroneously in his absence, then he just has to prove that he was not present in court on that day. In this case, it was clear that he was present in court.
Anything else that he has to prove?
Sorry, JP. I think, I don't know whether I've got brain fog or.
I think you have.
Yeah. I think he also has to go to the extent of showing that the judgment was actually erroneous, not just that he was absent. So it's not just left on the basis as he was not present, so he automatically has a right to have the judgment rescinded. But he also has to show that there are prospects that he would succeed. But we didn't go that far in this matter.
And in the prospects of succeeding, what would they have to prove?
That he has a reasonable case, and obviously that evidence has to be presented.
A bona fide defense.
But definitely a bona fide defense.
Yes. Okay.
Sometimes the obvious escapes us when you're sitting here.
Thank you. Thank you, Chief Justice.
Thank you.
Thank you, JP. Minister?
Thank you very much, CJ. Just one question from my side. Good afternoon, Advocate.
Nirkin.
How are you?
I'm good. How are you?
I'm okay. I have been asking this question of access to justice for our communities, especially those that are coming from the vulnerable communities. Are you able to share with us what mechanisms that the judiciary can put in place to ensure access to justice for the most vulnerable, especially in a rural province like KwaZulu-Natal, where majority of the people will have to travel long distances to access justice?
Well, I think we're fortunate when it comes to litigation. We've got the magistrates' courts, which are generally based in the community. With regard to the High Court, there may be a need to decentralize. I know there's talk about Richards Bay being an option of decentralizing, maybe having a seat in Richards Bay, but I think access to justice at the different levels, but it all comes down to what is. The ideal would be for everyone to be able to access the courts and have courts in as many localities as possible. But I think the first entry is at the magistrates' court. In communities, you will have traditional courts. But when it comes to the High Court in particular, maybe in a big province like KwaZulu-Natal, we need to look at further subdivision or further locations where the courts can be held. At the moment, we do have circuits that go out to areas where communities are based so that the matter can be dealt with on the circuit or in the locality or as close to the community as possible. The other thing is for access to justice. I think we've gone a long way as a country in terms of the establishment of the Legal Aid Board. But I think there we need to also look at roadshows or things that need to be done in the media to remind people that they can access the Legal Aid Board to represent them in litigation matters, whether it's criminal or civil. Maybe also we need to lower the bar in terms of entry requirements for them as well.
Thank you, CJ.
Thank you, Minister. We have reached the end of your interview now, Advocate. You said
Nirgin.
Nirgin.
We need to roll the R.
Yeah. Do forgive my unruly
No
tongue.
problem.
All right. Thank you for making the time to present yourself here.
Thank you. Thank you for giving me this opportunity, and I hope I can serve our nation.
You're excused. Colleagues, I propose that we take one more. He is a candidate who was here not so long ago, so I imagine that we'll use the principle to which we've Advocate Pittman.
Good afternoon, Chief Justice.
How are you?
I'm fine, thank you.
I'm good. You were here just exactly a year ago.
Exactly.
And we gave you a thorough going over. So I don't imagine that will be very long with you. We do have a full transcript of your previous interview for a position in the same division in front of us. You have a BA and an LLB from the University of KwaZulu-Natal,
Yes.
and you have been an advocate since 1994,
Yes.
practicing at which bar?
In
KZN.
In KZN.
But
Durban.
before that, you were a prosecutor for about 3 years.
I was a prosecutor for 3.5, 4 years, and 4 to 4.5 years, and a magistrate in the district
Then
criminal
a
court
magistrate.
4.5
For how long?
4.5 years also.
All right. You have not taken silk. I recall that last time you were here, you
No.
said you may go towards that direction.
Yes.
Have you taken any steps towards that direction?
Yes, I did.
Oh.
I made inquiries about the procedure that's currently applied in the context of the LPC and the bar, and I was informed that the current scheme of legislation, there is a committee that requires to consist of 2 senior attorneys, and because there aren't any in terms of the relevant legislation, the committee, there needs to be some adjustment made before applications can actually be considered. And that's when I put my name forward again for this position.
All right. Have you had another acting stint as a judge since your last interview?
Yes, I've just come off a 4-week stint.
Or for how long?
A 4-week stint.
All right. And what kind of cases did you do?
So it was in the Durban Civil Division. I did, for the first 2 weeks, a medical negligence trial, and for the second 2 weeks, the usual motion courts, opposed motions, judicial case management, etc.
All right. So, in addition to what you already know about you, what fresh, relevant information would you want to bring to our attention?
I don't think there's anything very special that's new with respect to Chief Justice. I would consider it an honor being a judge. I would consider it a great honor to be able to spend my last decade in law, serving the division, which has been so good to me. I have practiced law in the division of KZN for 40 years, in one form or another. It's either as a prosecutor, or a magistrate, or an advocate, or an acting judge. It's given me everything that I have in my life. It's become a part of me. I often say that I don't think that advocates can retire, because being an advocate becomes so much about your existence that if you retire, you're almost giving yourself up. But I just think that in the circumstances, I owe it to my division to at least make that 40 years worth of experience available, if it can be of any use. And I think becoming a judge is a calling rather than a professional step. And I feel that if the time is right, then I will be called.
Thank you. Judge President Poyotlot.
Thank you, Chief Justice. Good afternoon, Advocate Pittman.
Hello, JP.
Indeed, you acted in the past 4 weeks, and you were full of energy, I must say. You are going to be turning 65 in the next few days, and you know how the workload is in the division. Do you think you will be able to cope at your age?
Without a shadow of a doubt.
Yes. At least you have not given me or the DJP an indication that you might not be able to cope because of your age.
I love the work.
Yes. And in the reserve judgments, what is the longest time that you have taken to hand down a reserve judgment?
I see that from the responses by one of the associations that the longest time I took was 6 months in 2021 for a judgment. Other than that, they've all been within the 3 or 4 month period. The judgment in 2021 was a judgment that was a trial that I heard in a matter involving the Durban City Council, which was quite complicated. And my acting stint came to an end. It was in the Christmas period, etc., etc., and that was one of the reasons why the judgment was delayed a little bit. But it was complicated to the extent that in the last couple of years, it's wound its way finally through to the Constitutional Court. It's the double daily matter, where leave to appeal was finally disposed of, refused.
Yes.
So that's the longest.
And just on the acting stint that you've just had now, you were more than willing when I had to reshuffle the role in order for you to do at short notice with an opposed application.
Yes.
If you are recommended, will that not change?
No.
Because people tend to complain, particularly if you give a very short notice on a voluminous matter which is opposed. Will you not change? I do want that assurance.
Absolutely not, JP. I will not change. You will remember that, in fact, you bounced me with two unusual matters. The first was that medical negligence trial, which was due to go to another judge who couldn't do it. I was very happy to do it. In fact, I really enjoyed the matter. It involved experts from Scotland. And as for the opposed motions, can't wait to get into them in the future if you have me.
And then lastly, in the last interview, I'm sure you've had time to reflect and to also go through the transcript. Are there any lessons or anything that you took from that, and any self-correction, maybe if necessary? Is there anything that you've learned from that previous interview?
It's a difficult question. I think maybe I focused too much on the kind of human being I was rather than the job that I do. I was hoping that I could today focus on the job that I do and that I can do, and that the benefit I can be to our division.
Thank you. Thank you, Chief Justice.
Thank you, JP. Premier?
No, thank you, CJ. I have no question.
Commissioner Kotsal?
Thank you, CJ. Good afternoon.
Good afternoon, Commissioner.
Advocate Pittman.
Good afternoon, Commissioner.
The JSC was deliberately structured after 1994 to safeguard against the kind of narrow and unfair practices of appointing judges in the past. And law bodies were, as I understand it, intended to contribute a professional and transformational perspective to the balance. Now, in this process, I've noted that the BLA have changed their position on your candidacy since last year. And I was wondering how you firstly understand the respective roles of both the law bodies and the politicians and other role players in the JSC, but also what you make of the shift in their position.
All right. I think that in a multicultural society like the one we have, it's essential that judges reflect the demographics of the society that they serve. And in order to do that and to give legitimacy to the judges, I think the constitution of the JSC as it is today, which has lawyers as well as other representatives of society, is an excellent way of achieving that end result. Laws like clothes are meant to fit the people who have to wear them. And you can't do that unless you have a multicultural approach to the appointment of judges. The second question was, second part of your question, I'm sorry, I can't remember it.
I'm sorry, I should have asked it two sections. It's what you make of the change in the BI's positions nearly a year later.
To be honest with you, I didn't realize they changed their position, but I'm very humbled. I must just tell you that I'm very humbled by what they say at the moment. I think they remark about how my appointment would equalize the demographics or help towards the equalization of the demographics of our division. that to me is a humbling submission, and as a white male, and I appreciate it a lot.
If I may, CJ? If I might just.
Okay.
So my understanding is that the change was as a result of a reflection on what I think you termed it nursery chambers. And have you done anything in the past year to change or to enhance
Sorry,
that
I'm sorry to
nursery chamber?
So the nursery chambers I called it the nursery chambers, and it wasn't meant in any way to denigrate or the people who were in it. They were just too grateful for the opportunity to get chambers at a heavily subsidized and reduced rate. It initially was, you see, because when I started at the bar in 1994, everybody was in a building in Smith Street. And the top of the building had what was called the nursery chambers, and they were very small little chambers that newly admitted advocates could rent at a cheap rate. And I thought it would be a good idea to have that kind of scenario for our group of advocates. The nursery chambers was originally one room, which was subdivided up into different sets of chambers effectively. It's actually morphed now into a situation where on the floor that I'm on and around me, most of the chambers are shared by, with permission of the bar, are shared by junior advocates who just need the help financially. So it's actually improved.
Thank you, CJ.
Speaking for myself, I thought the name is quite endearing.
Thank you. Thank you.
Minister?
Thank you very much, CJ. Good afternoon, Advocate
Good afternoon. Good afternoon, Commissioner.
The first issue I just want, probably one question I would have around access to justice. And I'm particularly interested in this area when dealing with provinces such as KZN, which is a rural province, takes long in all the services that you provide for people to travel. And therefore, my issue is how can the judiciary play a role in ensuring that there's access to justice, especially for the most vulnerable people in our communities, where they might find, because of their legacy of apartheid, you have the infrastructure in various areas where it's not accessible to many people. How do you think that that could be corrected, and how can we ensure that those that are the most vulnerable, most needy, who do not have the resources, have access to justice?
Thank you. As an individual puisne judge, which I would be if I were to be selected, I'm not sure that there is very much that I can personally do. However, having said that, your question relates to the judiciary, so I'm going to answer it as if I'm talking about the judiciary as a whole rather than simply my position as a possible judge. It is true that our society is still scattered all over areas of South Africa that are inaccessible to even a motor vehicle. But it is also true that our judiciary has done a lot to render accessible facilities and services. I'm aware of the fact that there are circuit courts for the High Court who travel to various other areas in order to provide services to people who may not be able to get right the way into the big cities. As a public prosecutor, and as a magistrate, I was very aware of the fact that each district, the country is divided into districts, and each of the districts has its court system. And witnesses who had to come to court from outlying areas are given witness fees, their travel expenses are paid for, so that was a help. As far as criminal cases are concerned, where witnesses had to be brought as part of the state case, the investigating officer, the police force, would always ensure that they are brought to court. So I never got a sense that there were people out there who were desperately trying to get to a court and couldn't get there. But I'm sure that that is the situation in some occasions. Other than the fact that it might be a good idea for someone to sit down and have a look at whether there is a budget for or an opportunity to further extend circuit courts, create new circuit courts, or new district magistrates courts. I'm not certain how one would be able to deal with it completely. But I do think that our justice system and our judiciary have made leaps and bounds in making access to justice on that basis of availability of being able to get to court as simple as possible.
Thank you, CJ.
Thank you, Minister. Prof?
Thank you, CJ. Good afternoon, Advocate Pittman.
Good afternoon, Commissioner.
I had an education to read one of your judgment, which I found very interesting, by the way. It is found in page 137 of the paginated bundle. I'm not really sure if you have the same. It is MBFM
Yes.
versus, it was an application in terms of Rule 28 of the Uniform Rules of
Yes.
Court. But obviously emanating from the matrimonial, the divorce proceedings, I guess, that were before the court. What is interesting to me, it is what is stated in paragraph 11 of that judgment. And it doesn't appear to be wrong, and I'm not suggesting that you are wrong. It's just that I just want to understand the methodology. Perhaps maybe you may be right. My understanding in this matter is that the applicant wanted to amend their summons. And obviously, they attached what you refer to as irrelevant documents in the application. I'm not necessarily concerned about those applications. I'm concerned about the substance of the amendment. In that paragraph 11, you sort of provide guidance on how an amendment in relation to universal partnership should be done, and you refer to the essential years of that particular contract. What I want to ask is it permissible for the judge to provide a judicial advice in a judgment? In other words, to dictate how the party wants to amend their pleadings? Because my understanding, correct me if I'm wrong, is whether or not the grounds for amendment following the objection have actually been met. So I was just interested to understand the rationale behind giving when I'm reading this paragraph, it seems to be an advice, like, no, don't do it this way, do it that way. Is it something? And I'm not saying you are wrong. Perhaps I'm just curious about it.
Yes. That's an interesting question, I think. So, giving a judgment per se is always giving advice, because the judgment constitutes your reasons, includes your reasons for arriving at a conclusion, and for people reading it in the future, that will constitute some sort of advice. But that doesn't really answer your question. What your question is relating to here is whether, in this particular paragraph, I have sought to give legal advice unrelated to the judgment I was giving.
No. The question is, given the fact that the party, as I can see here, they are legally represented, and my understanding is their legal representation, legal representative advised them that we need to amend our papers in this way for us to get the relief that we ultimately are seeking. So they have done that already. You have reflected on the papers, and you have the view perhaps maybe that the amendment is not adequate, and then you are commenting on how it has to be, and you are going as far as providing the elements.
Yes.
And we are dealing with summons, because the summons, you'll have your course of action and the facts that support your course of action. And what I kind of see here is they actually amended to provide facts that support their course of action. So I was just interested as to what was your methodology in giving this advice.
Yes. So my thought process is this: to say to a party, look, you want to amend. You say this amendment is sufficient. This is actually what you require to demonstrate. You have or you haven't. In order for me to justify my reasons about when I say this is what you are required to plead the factor probanda, I would refer to authority as I have here. So it's part of the reasoning process that I've set out as to why I came to the conclusion that I did.
Very much.
Thank you.
Thank you, CJ.
Any further questions, colleagues? All right, that brings us to the conclusion of this interview, Advocate Pittman.
Thank you very much, Chief
Thank
Justice.
you. You're excused.
Thank you very much, Commissioners. May I go?
We take lunch, colleagues, until quarter to 2. Good afternoon, Advocate Sibisi.
Speaking. Good afternoon, CJ.
Are you well?
I'm fine, thank you. How are you?
May we start?
Yes, we can start.
All right. Oh, there it is. You obtained an LLB degree from the University of Natal, from my alma mater, the University of Natal in Devon,
That's
in
correct,
2000.
That's
in
correct.
2000. All right. And you did your articles at Nhlanhla Mnulwane Incorporated.
Yes, that's correct, CJ.
But then you didn't stay long there. What happened, if I may ask?
My articles I started at Nhlanhla Mnulwane Incorporated, and after just over 6 months, they were ceded to another law firm.
All right. And then they made you associate, and you moved on to another firm and another firm until you started your own practice.
That's correct.
And that was in 2008 now. But then you didn't stay long in that practice.
Yes,
You decided to become an advocate.
that's correct, CJ.
All right. And you have practiced as such since 2011.
Yes.
Okay. What kind of a practice do you have? What kind of
CJ?
work do you do?
I have a varied practice.
I'm sorry, just draw the mic closer to you.
Yes, thank you. I have a varied practice, but I deal mostly with personal injury law. I also have commercial work. But as I indicated, it's a varied practice, but I mostly deal with the 2 areas of law that I've mentioned.
And you have acted as a judge?
That's correct.
On a few occasions?
I beg your pardon, CJ?
You have acted as a judge on a few occasions?
Yes.
When exactly and where?
I started in 2023. I've had 9 stints. Yes.
Coming up to how long?
According to my calculations, it's 33 weeks.
All right. In the same division?
In the same division, but in both centers, Pietermaritzburg and Durban.
And you have sat in all the courts?
Yes, that's correct.
Right. Written judgments, I see.
Yes, I have written judgments as well.
Any of them reported?
They have not been reported.
Not yet. How many would you say you've written so far?
51 written judgments.
And not even one reported?
I've tried, CJ, but it hasn't been.
It's not up to you, is it?
I've only sent them to Safely, and they've only been
But they are
published.
available on Safely, I would imagine.
Some of them, yes.
Okay. I think I should stop here and allow Judge President Boyotlati to put you through the ropes.
Thank you, CJ. Good afternoon, Advocate CBC.
Good afternoon, JP.
You've acted both in Pietermaritzburg and in Durban. How have you found the colleagues?
The colleagues have been good, very helpful. I've learned a lot from them. I would say all the colleagues that I've worked with have made a difference in my life and made the transition easy.
Yes. And I assume you've had an opportunity to sit in full court and in full bench appeals.
That's correct, CJ. JP.
Yes. And in those, you've scribed some judgments.
That's correct.
And how was the feedback from the presiders with your judgments?
I've received good feedback. And in most of them, I've volunteered to be the scribe.
Yes.
With few areas I had to revisit in my draft judgments, but overall, the feedback that I got was good.
Yes. And I see that you sit as a chairperson of the tax board.
That's correct.
And you also write judgments there, I would assume.
Yes, I've written numerous judgments there as well.
And have any of them been taken on review?
Not that I'm aware of. I've never been notified of that.
And in the High Court, you have, as you have said, about 51 written judgments. What is the longest you've taken in handing down a judgment?
JP, unfortunately, there were about 2 matters where I took 5 months to deliver judgment.
Yes.
In circumstances where I had the matters towards the end of my acting stints and having to go back to my practice, so there were, I'll say, conflicting interest in that I had to maintain my practice, generate an income, but those are the 2 judgments that I'm aware of. It's 2 judgments that I'm not proud of because of the time that it took to deliver them.
Yes, I recall that I think I received 2 letters or so where the litigants were asking me to nudge you about those judgments.
Yes.
And what is the status of them now?
I've delivered to all my outstanding judgments.
So as you sit there today, there are no outstanding
I
judgments?
have nothing.
Yes. I'll come back to that because I had asked my office to just update me because I saw the comments from the GCP and other professional bodies. So I would want to just verify with you if there is anything negative. So coming back to the questions that I have, in the criminal matters, how many stints did you have? How many weeks were you able to do criminal matters?
I have the first one, the very first acting stint I had, I did crime. So it was about 5 weeks. So I completed the trial, a full trial, and there were some matters, guilty pleas, plea bargains that I dealt with. And then the last one, which ended on the 20th of September, the matter became part-head for a variety of reasons. We couldn't proceed, including the attorney being sick, the accused being sick, and the withdrawal of one of the attorneys as well.
Yes. So you have one criminal matter that you finalized?
Yes, one trial that I finalized.
One trial, yes. All right. So just one question on the criminal matters. Your understanding of Section 105, capital A of the Criminal Procedure Act, the plea bargaining.
Yes.
What are the considerations that a judge should have in accepting that plea?
JP, the judge should have a look at the agreement that the parties reached, so far as the conviction and the sentence are concerned. But if the presiding officer thinks that the sentence is not appropriate, then the presiding officer can reject the agreement in terms of Section 105.
Yes. And if a complainant or the families have not been consulted, what is it that you can do as a presiding officer?
Is to perhaps afford the family a chance to comment on the agreement between the accused and the state.
Yes.
Yes.
And just on the appeals, if a matter comes before the full bench, so that will be a decision of a magistrate before you, and the appeal is only in respect of sentence,
Yes.
but you are not satisfied about the conviction, what is it that you can do as a judge in order to deal with that issue? Must I repeat, or you are thinking about it?
I'm thinking about it
Yes.
because I've never encountered such a situation before.
Yes.
Um,
So if the person was convicted and
yes.
they come before you
Yes.
for sentence only, but you're not satisfied about the conviction.
I'm thinking off the cuff, JP. I will afford both parties a chance to address me on an issue that I'll be pointing out. If it means that I cannot deal with the matter rather than I can perhaps have the matter adjourned so that I can afford them a chance to deal with that. But I'm not too sure of my answers.
Yes, because I would imagine if there was no leave to appeal from the
Yes.
magistrate's court, would you be able to deal with it in the High Court?
I don't see how I can deal with it
Yeah.
because it was not dealt with on those bases.
Yeah.
Yes.
Thank you, Chief Justice.
Thank you, JP. Premier?
No, thank you, CJ. I have no question.
Professor Marumakai?
Thank you very much, CJ. Good morning. Oh, afternoon, I beg your
Good
pardon.
afternoon,
I mean this,
Commissioner.
Would it be a fair assessment that your strength is in criminal law?
It wouldn't be a fair assessment because I've not been exposed as much as I have been in the other areas of law. But I certainly have.
Which area of law would be your strength?
I'll say in the field of personal injury law.
Or personal injury law?
Yes. But then at the same time, I started off in a firm that does criminal work. And from time to time, I've handled criminal matters. So I'm familiar with it.
Oh, okay. Let me ask you a question nonetheless in criminal law. When one looks at the Criminal Procedure Act and you look at the schedules, different schedules, one would immediately realize that there is a duplication of offenses in various schedules. And sometimes it's not necessarily easy to determine which schedule is applicable in a particular matter. Because you'll see various crimes appearing on various schedules. But there are certain tests that are used for you to determine whether this is a Schedule 1, Schedule 2, Schedule 5, and Schedule 6. I'm more interested in Schedule 6 offenses. What generally renders a particular offense to be regarded as a Schedule 6 offense? And what is the test that ought to be satisfied by the accused if they want to be released on bail?
Yes. I would say that to answer the first part of your question, what determines categorizing a crime to fall under Schedule 6 I'll say it's seriousness of the offense. And then you asked me about the requirements for bail. It has to be exceptional circumstances have to be satisfied, which in the interest of justice supports the bail application in favor of the applicant.
Thank you very much. Thank you, CJ.
Commissioner Mange?
Thank you, Chief Justice. Good afternoon, Advocate CBC.
Good afternoon, Commissioner.
Yes. In the matter of Ahir versus Governor,
Yes.
Ms. Governor was apparently an unrepresented litigant.
Yes.
And when the matter came before you, she applied for a postponement and you refused it.
Yes, correct.
But reading the judgment, I am not able to find the basis upon which the request for a postponement. Why did you postpone? Did you refuse the request?
I had two reasons for that, Commissioner. The first one is that the matter was not initially allocated to me. It came before a different judge. She tried, in fact, she moved an application for a postponement before that judge, and it was refused. And then on the same day, when the matter was allocated to me after the recusal of the first judge, she applied for an adjournment again, but then did not elaborate on the reasons was in support of her application, other than saying that she's not represented. And it is this particular litigant also had applied in the past, previously, in the past for a postponement, which she got. So I didn't find sufficient reason to grant the postponement solely because she was not represented. I found the reasons were just not sufficient for me to grant, at least the ones that she was presented to me.
As I read the judgment,
yes,
the first request for a postponement was because the acting judge then came from the same bar with the counsel for the plaintiff, and the judge then recused himself on that basis. So the second time, when she made a request for a postponement, she said that she's not able to deal with the matter. And then you refuse the postponement. You are not explaining why you are refusing the postponement, nor are you offering any assistance to her in the form of either referring her to legal aid and or asking the bar counsel to make a counsel available to assist her.
Okay. The point that came when the first judge was dealing with the matter, that the acting judge was from the same group of advocates and as the plaintiff's counsel. That was the reason for the recusal, not for the postponement. And without repeating myself insofar as the postponement is concerned, Commissioner, I just felt as if the reasons that were advanced by her were not sufficient to warrant a postponement of a trial. So would have effectively meant that the trial was going to be postponed, if I'm not mistaken, for the third time. And I didn't get the impression that she was going to be prejudiced because she seemed to understand the factual issues that she had to deal with because she was, she created to me that impression that she was able to to deal with the matter on their own.
Thank you, Advocate CBC. Thank you, Chief Justice.
Thank you. Thank you. Good afternoon, Mr. CBC.
Good afternoon, Commissioner.
Yes, just as a follow-up, but perhaps then to rather raise it as a question of general principle. What are the factors that you would take into account, a judge takes into account when confronted with a request for a postponement? And did you consider those factors in this specific case that you were discussing?
Commissioner, I would say I considered what I considered. I considered what I thought was important in the circumstances that I looked at the reasons for the postponement, and it did not seem as if there was something new to what the applicant was raising, that is the defendant in the matter. I didn't get the impression that the postponement was going to serve any purpose. That is perhaps obtaining legal representation, because the matter had a long history. There were attorneys at some point that were involved. I think they were changed at some point, but I stand under correction. The matter had a long history, and those postponements that are spoke about, but it's she certainly did not support that case for warranting a postponement of a trial, in my view.
I was trying to move it away from this specific case, just to speak to what are the factors ordinarily that you would take into account. Forget the facts of this case.
Yeah, I'll consider questions like prejudice, for example, if the postponement is not granted, and perhaps deal with the question of cost then. But in this, as I indicated, without repeating what I've already said as well, that that's the main thing that I will look at, the question of prejudice.
Would you consider prejudice to the other as well?
Yes,
Or
yes,
just
yes.
consider
Both parties.
Thank you.
Thank you.
Commissioner King?
Thank you, CJ. This is a follow-up question. Good afternoon.
Good afternoon.
You've been asked two questions, one by the JP, if I recall correctly, and one by my fellow commissioner, relating to something that arises in your court, a criminal appeal where you sense an injustice has been done on the merits, a question of a postponement and how you deal with the issue. And this is obviously not an exam. We're expected to know everything off by heart. But when something like that arises, how would you find the correct answer? Where would you turn? How would you go about approaching something that arises where you don't immediately know the answer?
Yes, what I normally do, I normally do my own research, and if I still don't get the answer, then consult colleagues who might have dealt with the same point. So I wouldn't I wouldn't leave it at that, but I will certainly consult with senior colleagues.
Thank you.
Anyone else? All right. This is the end of the interview, Advocate CBC.
Thank you, Chief
You're
Justice.
excused.
Thank you, Chief Justice.
Good afternoon, RCP.
Good afternoon, CJ.
How are you?
I'm well, thank you, CJ. I hope you are well.
I'm fine, thanks. Are you ready?
Yes, I am ready.
You hold a big proc from the University of Transkei, of Walter Sisulu University, sorry.
Yes, I do, CJ.
And 2 further law degrees from UKZN, an LLB and an LLM.
Indeed, CJ.
LLM in medical law.
That is so, CJ.
What prompted that choice of medical law?
If you will note, it came quite late or when I was already at an advanced stage of my career. So throughout the work that I'd done, I saw a gap that I needed to understand more, and I needed a depth understanding of how injuries are interpreted, how those in the medical profession some reach their clinical decisions, so what informs them, and so forth. So as well, when I grew up, I had an interest in that field, but it was overtaken by a choice of law.
Right.
Thank you, CJ.
A significant portion of your legal career has been spent in the field of prosecution. You started as an acting public prosecutor in 1997 and built your way all the way up to senior state advocate by 2007.
Yes, that is so, CJ.
And then in 2011, you started acting as a regional magistrate.
That is so, CJ.
And you were permanently appointed in that position in 2013.
That is so, CJ.
And in 2022, you were promoted to regional court president.
Yes, CJ.
And then you have not had any breaks. You started acting as a judge in 2022.
Yes, in 2022, CJ.
And you've acted intermittently as a judge since.
That is so, CJ.
I see from your application form, that you've acted both in the division to which you are now applying in KZN and in Gauteng as well.
That is so, CJ. I also had an opportunity to act in the division of the Western Cape.
Oh, yes.
Yes.
How long did you act in KZN?
Most of my acting was in the division of KwaZulu-Natal. Then I acted in the Gauteng division in Pretoria for 5 weeks. And then in the division of the Western Cape, it was a total of 10 weeks. So out of about 50 weeks that I have acted, the rest was in KwaZulu-Natal.
How did you find the pace in Gauteng?
It was an interesting experience, and I think I was fortunate to be exposed to that division. That is where, for the first time, I came across case lines. So I have to equip myself quickly with that process. So it was an experience wherein I got to learn how to work on my laptop without any paper. And I was overwhelmed at the beginning, but within no time, I actually enjoyed it.
Yeah, I'm told once you get used to it, it actually is a pleasure. But it's difficult for the oldies such as me who want to feel paper between their fingers and smell paper, you know.
It is actually great to work on those case lines.
Yeah.
Yes.
All right. So you have sat in all the courts in these 3 divisions, doing criminal trials, civil trials, sitting in motion court, doing appeals and reviews, not so.
Come again, CJ?
I'm asking if you've had the opportunity to sit in all the courts. Well, you're a regional court president, so you would be used to conducting trials, both civil and criminal. What I want to find out is whether in the High Court you've had the opportunity to sit in motion court and sit in appeals, full court, and so on.
Thank you, CJ. I had an opportunity to sit in both the criminal court and the civil court. And whilst doing civil court, I was also doing a motion court. I've done motion court in all the 3 divisions where I have acted more than once. And having acted throughout, I also tried to count the times that I've done motion court, and I just realized it was more than 10 times that I have done motion court throughout. So having
in Gauteng and in the Western Cape as well.
that is so, CJ. I remember in Gauteng, for the 5 weeks I spent there, I did motion court on 2 occasions. And in the Western Cape, it was also on 2 occasions.
And you managed fine?
I managed very well. I actually enjoyed that kind of an exposure, because when you're doing motion court, you are not only dealing with one area of law, you are dealing with diverse areas of law, and you have to think fast, and you also have to equip yourself to familiarize with the files and the issues in each matter.
I know what you mean. I missed motion court for years after moving up to appellate division. You list a number of skills you have garnered as a regional court president, including case flow management and the training of staff such as registrars and staff key in our front offices. What would you do with these skills in the High Court? Because well, I don't know how well organized Judge President Boyodlati's court is, but I know in my court we struggle in the front office, and we struggle. So do you think those are skills you could impart if you are appointed to this court?
Certainly, CJ. You know, in the regional court, unlike the processes in the High Court, in terms of the planning of the roles, we do not place only one matter on the roll for trial, and we work on a continuous roll, and that equips us to be able to work with speed and to also ensure that we do not lose on court hours and court time. So working with the regional court in terms of case flow management, it means that you have to come up with innovative measures to ensure that the cases proceed and that the cases do not collapse. So working in the regional court and also as a leader in terms of the efficiency of case flow, I'd had also to be able to get cooperation from all stakeholders, and I'd had to work with them for a buy-in in terms of my vision on how we should improve on our case flow. So if I am appointed to the High Court, I will certainly take that with me, because from what I've seen, at the time that I've been acting in the High Court, when it comes to criminal cases, there can be as much organization, but they often collapse for one reason or the other. So having worked with other stakeholders in the regional court in terms of the organization and optimizing on the court hours, I've learned that we should not wait until we have a case law management meeting. We must have each other on our handsets to talk about the matters and to in advance to deal with what is likely to affect the flow of cases beforehand. So I think that is my strength in terms of organizing and ensuring that our cases do not collapse. Thank you, CJ.
You have had a lot of involvement in community outreach and initiated programs in rural areas and among the youth. Can you tell us a bit about that?
I must say, CJ, that has become my passion as well, because I saw that I enjoy that interaction. And having worked mainly in the rural part of the KwaZulu-Natal province, I observed that we needed to get ourselves out there to educate our communities, and as also part of creating access to justice to a point that I also thought that I could not do this alone. I needed other stakeholders as well to work with us on this. And I also developed a team pulling from the registrar, the NPA, the attorneys, and even some advocates to go out there and educate the communities. And that worked very well. But at some point, because I spent about 8 years in the Northern Zululand area, and I was the only judicial officer that was running the 3 courts there, I thought to myself, okay, now I had to minimize my active encounter with the communities. So I roped in younger colleagues from the administration and the support services, and we developed a calendar when they would take turns weekly to go out there and educate the communities. We also adopted the University of Zululand, wherein they would also take turns to attend to the students in bigger numbers so that they could educate them. So, but there I had to be involved behind the scenes in terms of the content of what was given to the students. I'm not sure if I have covered that well.
That's enough. The most important part of this job, of course, is judgment writing. Have you had opportunity to produce any?
I have, CJ. Throughout the time that I have acted, I have penned up to 48 written judgments. And this excludes the extempores that I would do on from time to time. And I must say, having also worked with senior judges on the full bench and on, excuse me, on appeals, I would ensure that I volunteered to be the scribe because I was capitalizing on the wealth of experience that I was exposed to.
So I would rather be a scribe so that they can critique my work, so that I can also learn from them. So that gave me an opportunity to develop my skills in judgment writing, and to also work with the senior judges so that I got guidance and also improved on my skills. I also ensured that I make myself available to attend training, and to also work with other colleagues in terms of workshopping each other on the approach to judgment writing. But this, of course, I would do with my regional court colleagues. Thank you.
I see that the judgments you have listed as your most significant are in the field of criminal law. Is that because that's where you're most comfortable?
I think, CJ, the judgments that I have included in my application, I think there's 6 of them.
Yeah.
Yes, it's
On a wide range.
two that are on criminal law. It is one review, it is a brief, short judgment that I wrote, and the other one is a criminal appeal. And the criminal appeal, I thought I should attach it because I wrote it, I was a scribe in the Gauteng division. So I was also trying to blend what I made available in terms of the exposure that I got from the 3 divisions.
Have you delivered the judgments listed as reserved in your application form?
Yes, CJ, they have all been delivered. However, I must also mention that since I've been acting now in KZN, I have since picked up 2 other judgments that are still outstanding.
But that's only recently.
That those that I picked up now when I was acting in KZN.
When was that?
Now in August, September. Yes, CJ.
Thank you, Regional Court President JP Boydrat.
Thank you, CJ. Good afternoon, Mr. Punzi.
Good afternoon, JP.
Yes, just follow up on CJ's question about your community involvement, and it's something that I don't know how to put it, but there was a, whether in 2022 or 2023, you were acting in the High Court, and it was AIDS World Day.
Oh, yes, I remember.
Yes, we were not quite aware, I would imagine, some of our colleagues, but you made us all to participate in that ceremony in a tea room, if you recall. And you were so passionate about it. Was there a driving force behind that?
I don't know. It just came naturally with me that I thought this is such an important day to observe. And for me, I could see from the body language of the seniors there that they did not appear to be conscious that it was going to be a World AIDS Day. So I thought in the afternoon when I left work that, I'm going to get candles and ribbons and just to conscientize the seniors that this is such an important day, and that we, as part of the community, are needed to observe it, just to give that human part in us as the judicial officers.
Yes, I recall that because there were quite a few senior colleagues, some of whom have retired, and you were not taking no for an answer. You were putting ribbons on their pockets and everything, and I was like, wow, this is another person that we have. All right. No, that's very good to bring awareness to the judiciary and to bring the human element to it. Coming back, I see that from being a prosecutor, you then acted in the regional court. The norm seems to be from prosecutor to district court and then to regional court, but you don't seem to have followed that norm.
Yes. And indeed, JP, at that time, I was the senior state advocate in the KZN division. And I got to read from publications around and also in terms of the performance of the courts. I got to learn that the Department of Justice at that time was working on dealing with backlogs in the courts, and there was also establishment of backlog courts, and the focus was at that time mainly on the backlogs that were accumulating in the sexual offences courts. And I also had some form of a passion in relation to sexual offences courts. So I just thought to myself, let me put myself out there, available to preside in those backlog courts, because I thought to myself this was an opportunity for me to contribute from a different angle in terms of access to justice. And that is how then I really pushed for myself to get an opportunity to contribute from that side. I was fortunate that then I did get that opportunity, and I think I fared well in terms of my objectives.
Yes. And have you ever faced any disciplinary issues whilst in the prosecution?
In the prosecution, I started in 1997, straight from university, and I stayed in the prosecution until 2011. I have never faced any form of disciplinary inquiries or an investigation, either on my personal capacity or on my professional capacity. In fact, if I can also disclose, even when I left the NPA, they were still trying to get me back to the NPA to say there were positions that I could still take advantage of and avail myself to the NPA. But I thought to myself, no, I was pursuing another angle of my career. Then I did not go back to the NPA.
Yes. And in the magistracy, have you ever faced any disciplinary proceedings?
No, JP, I have never faced any disciplinary investigations or inquiries through the Magistrates Commission.
And the Magistrates Commission has never investigated you from a complaint that they received?
No, not at all. They have never investigated me.
Yes. And in fact, the complaint that caused you to withdraw the last time was because it had been received in the division, perhaps CJ, I can say, before I recommend candidates for appointment, I circulate names to the colleagues, and I ask them to comment if there are any issues before I recommend their acting appointments to the minister. Once I don't get any negative comments, then I recommend to the minister. And during that window, when I had asked colleagues to comment about the candidates that were going to act, it is then that a complaint arose directly to the JSC and to myself, but not to the Magistrates Commission. Do you recall?
I do recall that, JP, and you brought it to my attention.
Yes.
Yes.
And from that complaint, the Magistrates Commission tried to investigate it, but they could not put a face to the complaint because nobody knew of the RR Naidu that was the complainant.
When I came across it, I was quite shocked, and I was taken aback because I have been in the profession
for more than 20 years, and there had never been anything like that on my name. So I thought, no, this is so much. And I also brought it to the attention of the Magistrate Commission to pursue it and to investigate it. And then they reverted back to say that they tried to trace that person. That person was not known. That person could not be located. In fact, I must also mention that I do not know any person by R.R. Naidu, and I have never worked with a person with the names R.R. Naidu. I also tried to think deep and afar. Throughout my profession, I have never come across that character. So when I also was interacting with the Magistrate Commission, I was also insisting on them that they needed to take this matter up and investigate it so that we could get to the bottom of it.
Yes, and in fact, if the R.R. Naidu existed and had been a retired magistrate, they would have known that they must lodge the complaint with the Magistrates Commission. Is that so? Because you were a magistrate at the time.
Indeed, JP. And it would appear from what R.R. Naidu wrote that they must have been a senior person up until the time they retired as a magistrate. So he or she would have known what processes to follow. Insofar as if they had any concerns about my character or the character of any other judicial officer for that matter.
Yes. Now, your
perhaps JP, I should have mentioned. I don't know if it was brought to your attention that the JSC's objections committee actually considered this matter and took a decision that I'll just read their final determination that, bearing in mind the steps taken by the candidate to clear her name of these allegations, and the fact that the letter from this R.R. Naidu is not in fact supported by any proof, it would be prejudicial to put such material to Ms. Sipunzi when she's shown that the allegations are possibly without foundation. But I thought I'd let you have a go at it, because these allegations were widespread in our community, and this might well be a chance for her to speak on them.
Precisely,
So.
CJ. I did see the decision of the objections committee, but it is an issue that was flagged by, I think, by AFT as well as the GCB. So I thought I needed to just get that out of the way in a way, per se. Yes, thank you, CJ. But I move away from that now. As the regional court president in the Western Cape, firstly, I'm glad that you chose KZN because you've acted in 3 divisions, but you chose to make yourself available. And this question has been asked previously, relating to the performance of the regional court. Have you shared some of what you are doing in the Western Cape to the acting RCP in KZN in terms of performance of the regional courts? Because it's an area that we are seriously grappling with.
Thank you, JP. As the regional court presidents, we have what is called the Regional Court Presidents Forum, where 9 of us sit together. We do share our best practices. We do share a lot in terms of how we approach our work and how we deal with the challenges that we encounter in our regions. So without directly telling a colleague what they would do, I think that from what we've been sharing together as regional court presidents, I'm certain that he understands and he knows my approach to work and to the challenges that we encounter as regional court presidents.
Yes. And further, on the civil matters, in KZN, I established a month ago that on average we deal with 70% of matters that ought to be dealt with in the lower courts, and only 30% ought to come to the High Court in terms of the monetary value. But because of the judgment of the SCA, we deal with everything. Have you done anything practically to try and get practitioners to be comfortable to bring matters into the regional court, especially civil matters?
Thank you, JP. That is one of the first things that I looked into when I got to commence my duties as the regional court president, was to look at the work that we were doing as the regional court, qualitatively and quantitatively. And insofar as the quality, I then got to a point that, okay, we needed to capacitate our assistant registrars and the registrars, because they are the face of the regional court in terms of developing confidence in the litigants at the first time and at their first encounter with the regional court. So I organized other stakeholders. I can remember the head of the legal aid there, the head of the state advocate, and some senior attorneys in the profession and other colleagues. We put together all the assistant registrars. We had like 42 of them in one room, and we developed a curriculum for them for a period of a week. And we were fortunate that we got support from our regional head to sponsor us in terms of accommodation and everything that we needed to provide the training. So we had that training, and I was pleased with the outcome and the reflections that we got, not only from the assistant registrars that were subjected to the training, but even from now the litigants in the form of their representatives, the attorneys. They were pleased in terms of our improved output, in terms of now the quality that we were able to provide in our work. As well, I took it upon myself, when I see that there is a gap somewhere, I go into court myself. And I consciously did this in civil courts. I go and sit there and preside over the cases myself. This is not only to deal with the cases, but also to show the colleagues that this is how it's done in terms of starting the court early, that is optimizing on your court time. And in terms of preparation, I always insist on them. You can't just go into a civil court without having read your files, without having prepared. And I encourage them continuously in terms of that, to say, this is how then you will engage with your practitioners if you had prepared. And this is how the practitioners as well will develop confidence in you, even if they were reluctant. So what I'm trying to say is that the focus, I think it has to be in terms of doing the groundwork behind the scenes, in terms of incapacitating colleagues and the value chain in general.
Thank you. And then lastly, if you have an application that has a dispute of facts before you, using the applicable principles, what orders can you give as a presiding judge?
Thank you, JP. In motion proceedings, there is a principle that we apply when we are faced with a dispute of fact, and that is become to be known as the plus con evens rule. And the plus con evens rule is where the court is able to make a finding on the facts, even though there is a dispute of fact, without having had oral evidence in terms of that dispute of fact. And when you utilize the plus con evens rule, you then make your ruling and the determination only on the papers. The other, and then you make a finding on that dispute of fact. And then the other way that you can deal with it is that if you see that this is a material dispute of fact that cannot be resolved only on the papers, then you will make an order directing that the application is then reverted to oral evidence. And then you specify in your order in terms of the focus, and that is in Rule 6, I think 5G of the Uniform Rules.
Thank you. Thank you, Chief Justice.
Thank you, JP. Premier?
CJ, I'm satisfied. No
Thank
question.
you. Commissioner Godsell, followed by Professor Merumafai.
Thank you, CJ. Good afternoon, Ms. Sipunzi.
Good afternoon, Commissioner.
You listed as part of the matters that you've dealt with that you've also had to apply the Child Justice Act. Is that correct?
That is so, Commissioner.
And you're from the Western Cape, so I was wondering if you recall the case of the teenager that was murdered about a year ago by another teenager who had previously been in conflict with the law. Not sure if you recall. Anyway, she was murdered by, allegedly murdered by a fellow pupil, and it then emerged that he had previously been in conflict with the law. But because of his age at the time, he was released in the care of his parents. Now, the Child Justice Act is built on restorative principles. But many of our courts, particularly outside of metropolitan areas, lack the capacity to give meaningful effect to those principles. Now, in your view, what is the role of a judicial officer in safeguarding the rights of a child who is in conflict with the law, especially when the state system or systems may not always be able to uphold those rights?
Thank you, Commissioner. When it comes to children, we are enjoined by the Constitution in terms of Section 28 of the Constitution to ensure that the best interest of the child are taken into account when dealing with matters that involve children. In regard to the court processes, the Child Justice Act makes it mandatory that when we are dealing with children that are in conflict or allegedly in conflict with the law, those children must be processed through what is called the preliminary inquiries. In that process, that is where now we try and assist this child so that if it is not necessary for this child to have a previous conviction, that they are dealt with through that rather restorative justice process, and that the probation officer, which is a social worker that would be conversant with how to deal with children, will then assess the child and assist the court in terms of making a determination on whether that child should finally be subjected to the processes of the court. So I think we need to be consistent as judicial officers in ensuring that we make use of that provision so that children are not unnecessarily exposed to the court system.
Thank you. Yes, I think using the word consistent is important, because in this case, what the psychologist and the psychiatrists found was that the child will, again, be in conflict with the law, and he was, but he was released. But I thank you for the answer, and I appreciate it.
Thank you, Commissioner.
Thank you, CJ.
Commissioner Marumafai?
Thank you, CJ. Good afternoon.
Good afternoon, Commissioner.
I was quite happy when you answered the JP on the Plascons case, because I want to take you to a case where it demonstrates to me that you read that particular case. Obviously, the principle that JP was dealing with is not necessarily, contrary to public opinion, it's not necessarily the main principle in that case. That case dealt with trademarks and how you deal with confusing marks and how you need to operate with them. And you have written a judgment that dealt with passing off. Do you remember that judgment?
Oh yes, I do. I remember the fuel traders,
Yes.
trailers, and yes, truck and
perhaps-
trailers.
Yes, perhaps if I can take you to page 56 of your document, where that judgment actually appears.
Yes, I've got it, Commissioner.
And this is where you rely on the main principle that comes from that case, and correctly so. But I want to ask you about something. If I can take you to paragraph 11 of that judgment.
Yes, Commissioner.
In that paragraph, actually, I'm sorry, paragraph 2 of that judgment. In that paragraph, you restate what is contained in a notice of motion. And it appears to me that what the parties were asking for, it was passing off, which is a common law unlawful competition intellectual remedy. Then in the alternative, they asked for a trademark sort of related order. But when I look at the judgment, I see that the order that you grant, it is similar to what is contained in the notice of motion. It is not quite clear to me in the judgment as to whether you dealt with passing off and you are of the view that passing off was actually proven, or all the alternatives that were provided in the notice of motion were actually proven for you to actually grant the order in the way in which it was granted, because it is passing off or then or. I'm not really sure you get my question. Just want to get clarity as to when the parties are coming to you and they are asking orders, at least in the alternative, do you just give those orders as they have been asked in the notice of motion? Or do you go through an exercise to show whether something has been proven and you are satisfied?
I don't know if I understand you, Commissioner. I'm looking at the paragraph 2, and I don't seem to see where part of
Sorry,
the
let me assist you. On Roman figure 1, right, it says the
Yes.
respondent is interdicted and restricted from passing off. That's the first thing. Then it says, or representing to the public at large that it operates as part of the applicant. Now, that is a remedy in terms of, as I can see it, in terms of either Section 11.2, Section 11, subsection 2 of the Companies Act, or Section 34 of the Trademarks Act. That is a pure competition, a pure trademark sort of question. Then it goes on to say, or any get up which is confusingly or deceptively similar to the applicant. So now that also is a trademark question. So what I'm asking is, on the one hand, there is a passing off request from you. Then there are 2 alternative trademark requests. So what I'm trying to ask you is, when you look at the facts as you deal with them, did you find that all of those things were proven for you to order them in the alternative?
Thank you, Commissioner. My understanding of that subparagraph, Roman figure 1, is that it encompasses all that the applicant was seeking. And in terms of my analysis of the evidence and the submissions, I found that the applicant had actually established that what they were seeking in their notice of motion. I did not understand it to be in the alternative, but that this is what they sought in terms of their application. I'm not sure if we understand each other.
No, I hear you. I guess perhaps my problem comes from, we know that passing off, you can deal with it strictly under the common law.
Yes.
The
yes.
2 alternatives, there are specific statutes in South Africa that deal with that. And it doesn't seem like you are addressing those. Because for you to be able to prove the second alternative, you have to rely on Section 11, subsection 2 of the Companies Act. And for you to prove the third alternative, you need to rely on Section 34 of the Trademarks Act. And you don't deal with those 2 legislation.
I take your point, Commissioner. However, my understanding of the flow of the arguments and the submissions and what the applicant sought was mainly based on what they alleged amounted to the passing off. And that as they allege that this is what amounted to the passing off, it included that they get up and the characteristics of the characteristic of the mark was that what inclusive, all inclusive, amounted to the passing off of the applicant.
No, thank you very much. Perhaps maybe you may want to look into those.
I
Thank you very
see.
much, CJ.
Thank you.
No further questions, colleagues? All right, that's it then, Regional Court President. We've reached the end of your interview. Thank you very much for making yourself available.
Okay, thank you, CJ, and thank you to the commissioners.
You're excused. Switched on. Good afternoon.
Good afternoon, Chief Justice, and good afternoon to the Commission.
How are you?
It's a big question.
It is.
Trepidation and hopeful, and I think alive, really.
Yeah, alive.
Yes.
Well, this is not your first time here, so I've no doubt that you're going to do just fine. Shall we start?
Yes, we may. Thank you,
All right.
Chief Justice.
Yours is not the usual application. You are not here to be vetted on your competence to become a judge. You are already a senior judge who seeks a lateral transfer to another division for personal reasons that are known to this body. And you were actually interviewed by this body not so long ago for a position at the Supreme Court of Appeal. So we have your transcript in our pocket. We have a very fair idea of who you are and what you are capable of. So I'll just zoom in on the highlights of your very extensive CV.
Thank you.
You have a number of academic qualifications, 3 degrees, social work honors, and an LLB from the University of Cape Town. All 3 of them? No, sorry.
No.
2 of them.
2. The first 2 from the University of Cape Town, and the LLB from
UKZN.
Yes,
Now.
Durban campus.
Yes. Howard
Natal
College.
as it then was.
And you also have a certificate, a global faculty development certificate from Wharton Business School at the University of Pennsylvania.
Yes.
And you are an accredited IMSA holding a certificate from that, an arbitration certificate from that body.
Yes.
Okay. You interned at CALS in the very beginning of your legal career, and then did articles and worked your way up to finally having your own law practice.
Yes.
And you did your articles with Cheryl Thompson and Tyson.
That is correct, Chief Justice.
And at some stage, you were a director at one of the biggest commercial law firms in the country, Cliff Decker.
That was towards the end of my foray, doing my own gig, I shall say. Yes.
And you were appointed to the bench from that law firm, weren't you?
Yes, I was.
And that was in 2017.
January 20th, 2017, Chief Justice, yes.
And appointed to the Gauteng Division of the High Court.
That is correct, Chief Justice.
And after your appointment as a judge, you had occasion to work at the Special Investigation Unit Tribunal.
Yes, at the establishment phase, yes.
That was between 2019 and 2022.
Yes.
Okay. What kind of work did the tribunal do?
Well, it was specifically set up to recover monies which had been appropriated, misappropriated. But at the early stages, obviously, the referrals and the work was slow, and we had to set up a management system and structure for which to operate, including the rules for the tribunal and the like, and do a lot of coordination between the hearing of the matters, getting the case managed for hearing with the SIU investigating team. Because even though they had a whole list of matters, it didn't mean that they were ready for adjudication at the time. So there was a lot of groundwork going on behind the scenes to get the matters ready.
You've acted at the Competition Appeal Court as well.
Yes, I have.
Had a number of stints there. Did you manage to write any judgment?
Yes, I did.
Oh, how many?
I did. I'll tell you, I think most people are not aware, because the Competition Appeals Court is not a full-time court. What happened is, at the end of the tenure of the previous presidency, there was almost like a gap, and matters come on an ad hoc basis, as and when they are ready for hearing. And so you don't have a deluge of matters on demand for hearing. For example, the 1 year I was appointed, but I only got to hear a matter once at the end of the year, which means there wasn't a demand for matters to be heard. So when people come and they have maybe 1 or 2 judgments having said it's not because of anything, just that there isn't sometimes as much a demand as to warrant a full-time court. So that's sometimes behind it. I've written 3 judgments for the court, and I hope to write some more.
Also, you are still interested in.
I love the work. I think I've also just recently, I've been asking them to make sure that it's published. I've just completed, but it's not for the competition court, but it overlays both administrative law and competition law issues involving market regulation of the mobile telecommunications market. It should be out in the market by now for critique.
Yeah. You acted at the Supreme Court of Appeal for a year?
Yes, I did.
How did you find it there?
You know, Chief Justice, the intellectual rigor of the work appeals to me. It truly, really does. And the advantage of being at the appellate court is that you get your records on time, and your work is really structured because you know exactly what you're going to be dealing with when the term starts. So if you were prepared and you use your time wisely, barring the interruption of the petitions, which obviously take precedent during the time of preparation, it's really very interesting work. And so, yeah, I like to be intellectually challenged. And so I found it particularly stimulating and interesting from that point of view.
I know that you wrote a number of judgments for that court. How many in all?
I did write 8 of my own. And I had one where I was assigned scribe with another colleague. And I wrote 3 dissenting judgments. One was not material, but it dealt with what subsequently the Constitutional Court referred to as a slap suit. And I think the other dissenting judgment I dealt with involved a tender involving Transnet, and whether I think the dispute centered on a narrow issue of whether or not the tender should be declared invalid and set aside. And the majority of the panel took a different view, and I, as a scribe for the minority, obviously took a different view because I was leaning on my experience around infrastructure procurement. Here, the other party delivered a fence which was not specified, and it centered on the diameters of the fence that was eventually installed, which was not ordered by Transnet. And when you've done PPP work and other work, there's what in the public procurement space is called value for money. That unless you have determined cumulatively what the impact of all of that was and whether Transnet got value for money, in my mind, the tender was irregular and it failed to be set aside. Because you can absolutely maximize on the margin by just delivering just a little bit less than what is specified. but cumulatively, it has an impact on the price paid. So I dissented on that one, and I co-wrote with a colleague a dissenting judgment involving the Consumer Tribunal and the liquidators. I think that judgment is before the Constitutional Court now to resolve, from what I can remember. And I think the GCB did pick up the one other dissenting judgment of whether or not the appeal was properly before the court. Whilst the majority went against me, and the senior judge van der Merwe and I took the view that the judgment is a nullity, I learned later that in fact the majority judgment was set aside, which was rather quite surprising and soon, which in effect affirmed the minority judgment I had written.
Yes. You've done a lot of things. I just
the way
I
you
get
say
a headache
it.
just thinking about it. But you are considered a premier expert on corporate governance issues. Just a little bit on that.
Well, maybe I should now say, now that I've spent 8 years and 8 months on the bench, maybe let me make it historical and say I was, right? I was. And I was an expert in the area. And governance is about how institutions are led and directed. And it combines a clear understanding of the regulatory framework within which the institution operates, and it calls for a proper distillation of what that framework means in terms of both leadership and governance, and setting up systems of, we don't talk compliance anymore, we talk conformance, which means what measures are there or created to ensure that the system not only complies, but performs on some of the key deliverables, which are almost invariably regulated by law. So part of my work was to translate legal principles into behaviors and systems of governance. And working with some of the listed majors, I worked with some of the boards, again, the listed majors, to help the board evaluate its performance within the regulatory framework, and as part of the culture of continual improvement. And I learned a lot from that work. I learned a lot.
Any of it relevant for what you're doing now?
Well, I think what it does is that it gives me insight. You know, some litigation comes before us, and it gives me deep insight into what the driver of the litigation is, and what's the underbelly that informs the litigation, and sometimes what strategy is that informs the litigation. And I see that sometimes there is a disconnect between, for example, what the company espouses as values and what is brought before court. And it assisted me a lot around contract law and around company law.
All right. I'm not going to get into all the bodies, legal and otherwise, in which you've been involved. Your CV is there, speaks for itself. I will just mention your involvement in judicial training of aspirant judges.
Yes.
Both here at home and regionally and globally, not so.
Well, not globally. I think,
What's your involvement with the United Nations?
well, I was the representative, local representative of the United Nations Global Compact in South Africa, which looks at the full value of what is come to known as sustainability. And that includes environmental governance and social governance.
And you've done a lot of work with SAJE.
Yes, I did until recently.
Yes.
Until recently, yes.
And the African Regional Judges Forum.
Yes.
One of the law bodies who've commented on your application worries that you might not cope with the workload of this division to which you apply. And I smiled to myself. You're a judge of the Johannesburg High Court, not so, where the working pace is frenetic, I'm told. So you used to.
Yeah.
Mm-hmm.
I didn't know how to receive the comment, because I mean soon after my surgery, I was off from June and September. Even though I was given a dispensation to work from home, I was full on. I know that my JP had said, look, we will try and ease you slowly so that you can, have time to heal. I think the judgments themselves and the roster itself speaks to the fact that I was not spared. So I ran with the project.
Mm. So you would not struggle with the workload down in KwaZulu-Natal, would you?
I've been working there. I started there in July in person.
Mm.
I haven't found myself struggling, and I think the JP, when she comes to ask me some questions, it is adaptation. And I think any change needs time for adaptation. But I wouldn't call that a struggle, because they've got different work systems. I must say, incredible infrastructure and support, and the fact that I can be at home helps me a hell of a lot, because I don't have to manage a lot, and I can just concentrate on either getting to Pietermaritzburg or getting to Durban and just sitting down and doing my work. So.
And it's working out well for you?
I love it. I'm sorry to say this, but I really do love it.
Why are you sorry?
No, I'm like, most people probably don't understand that there are two elements to it. Obviously, I'm closer to my doctors and I get the help that I need, and then I'm at home. But most people don't understand that from 1994, I made a decision, or my late husband and I made a decision to create a home for our children. And regardless of where I would have been in the world, KZN was my home. And KZN, that's where I established my illustrious practice, if I dare say. And KZN gave me a lot. KZN gave me the foundation to be where I am today. And it's like a whole T.S. Eliot thing. I've traveled everywhere, and then I've come to where it all started, from a personal legal practice point of view. And so I love that I'm able to be there and at least share what I know to the extent needed. I'm really grateful even for the opportunity to, I go there willingly, I go there happily.
All right. Judge President Boyoflat.
Thank you, CJ. Good afternoon, Judge Sewendo.
Good afternoon, JP.
I wanted to say, when you were saying it, it all started there and it gave you an illustrious career. I wanted to say, but watatwa li Gauteng. Then you were taken by Gauteng. So I'm sure we will be pleased to, if this body agrees, to welcome you back.
Not to talk down Gauteng, but not all that is gold glitters. You know, so.
And when you said,
careful now, the Gautengers sitting
Yeah,
around this
I
table.
know, I'm not saying, no, they mustn't take it personally, but honestly, I mean it in my case, at least. Not all that is gold that glitters, definitely.
yes, you've been in KZN now for about 10, 11 weeks.
Yes.
That's just more than a term. How have you found the division? You've sat both in Devon and Pietermaritzburg.
Yes, it runs differently. There's no question about it. Initially, I thought, well, the first offender for efficiencies is the RAF, and I think that is experienced by the courts across the country, across centers, and it clogs the role unnecessarily. There are obvious differences in that KZN doesn't have the volume that Gauteng judges experience, and that's really truth on the numbers. For example, you run a combined role in terms of motion court, so you will do both unopposed and opposed matters and urgent matters when you are assigned as a judge that week. And I'd been talking to one of the senior judges about it. Because of the volumes, there's no justification to allocate, for example, a single judge to hear urgent matters at all. So all the work gets done there. It took me a little bit of time to try and adjust to that, but there is some logic to it. And there's also just the use of technology is obviously not as ahead as Johannesburg or Gauteng has. We're so used to working off cotton line and case lines. And sometimes there is resistance to change. One needs to be sensitive towards that. But I think with a little bit of change management, people will start to see the value in using technology. Because I could have had all my files for next week in my computer with me and read them in between, instead of thinking I must carry the paper files and so on. Yeah, so those are just the broad differences. There is obviously work that I wasn't used to that I am now doing. There's the mental health reviews and petitions. They come in any time, but they're not a problem at all. And lastly, there's just the feel of the court. I attribute it to how it's led. I've got no idea what you as the leader of the court go through on a day-to-day basis, but the feel is settling to my nervous system, and it enables me to want to do more, want to give.
Thank you for that. And how have my colleagues been towards you?
So because there are traditions in that court, Like-
and you can't talk about our Thursday traditions.
Oh.
You can talk about others. I'm joking.
No, there are traditions, and I think for me this is where conscious female leadership has incredible value, because it must have taken thinking and effort to ensure that colleagues gather every morning together for tea before you start. And that space, and in fact it's compulsory, it's not optional. All of us come around tea. And that is the space to share developments, to share what the problems are and what's coming in the week, what's hitting us in the coming week. And it's like very useful. And then we've got a compulsory lunch together on Thursdays. And it's very intimate. And it's really very human. And we celebrate Heritage Day by marking the multicultural nature of our nation, coming together, bringing our traditional food. I thought that was like absolutely wonderful. And maybe it's just the benefit of having a smaller court that you can rally the troops to do that. But it takes awareness and thinking of how to bring people together and how to create a field where, you know, you can come in, not be anxious about your work, and knowing that you can lean on your colleagues when it's needed. And I'm not going to talk about the other parts because you've stopped me.
And I can just put it on record that in the 10 weeks or 11 weeks that you have been in KZN, you have not reported sick on any day. So I'm comfortable that you will be able to cope if this body agrees to recommend you to move to KZN.
Yeah, I mean, if you look at my stats, I don't know if you've got it. I mean, if you've looked at my stats, I probably disposed of more than 230, 300 motions. You assigned me a special motion on day one. The judgment is out. I've done urgent court matters in between when I was sitting in opposed motion. And I sort of have a tradition, and I think it's a Joburg tradition, that if you do give an order, even if the matter is small, do give some reasons. And I've probably given 5 reasons over and above a big special motion, which is out. I can't see myself not. I love working, and maybe too much. I can't see myself not doing it under the right conditions. And you make those conditions easy. You make me want to give.
And then lastly, thank you for that. And then lastly, Judge Suwendu, in Gauteng, as well as KZN, your average is about 2-3 months. What is the secret, particularly when you're based in Joburg?
Well, the secret is that you are going to make big mistakes sometimes. And you are really going to want to hide under your desk. Where matters are not, I think the call for 3 months for complex matters is, it really needs to be relooked at. And I think there was some conversation around that. The idea is to have that space to read ahead. And it's absolutely invaluable, because by the time you get to the parties, You've distilled exactly what the issues are, and then you don't sit on the judgment, even if it's difficult. So sometimes you can write 3 judgments, 4 judgments, all on a rolling roll at one go, so that by the time the one is finished, because it is like a conveyor belt, it just never stops. But for complex matters, one needs more time to step back from the matter. And there is a writer's block sometimes, you know, especially when you are confronted with the new territory. First, you've got to get to know what is the underbelly, and then you can sometimes write. I'm not speaking for colleagues in this sense, but I can imagine anyone who's involved in creative writing would understand that sometimes you can freeze when you are confronted with an area of law that you've not been exposed to, for example. So you need a little bit of time. And I think most of the time parties are understanding. But you've got to communicate to the parties. You don't sit in a corner and at the hour off say, oh, by the way, you know. So, yeah, it's a lot of risk taking. And sometimes you make errors and you've got to forgive yourself for those. But you just carry on and not sit on matters.
Thank you, Chief Justice.
Thank you, JP. Premier?
Thank you, CJ. No, I have no question.
Commissioner Matolo Tlepo?
Thank you, CJ. Good afternoon, Just Wendy.
Good afternoon, Commissioner
It's such
Matolo
refreshing. It's so refreshing to see you back here. And I was just reading the comments by the law bodies about your work ethic, that you can't cope. I just wanted to highlight to them that they must thank you for being a vanguard to making sure that the Legal Practice Act is what it is now.
I'm glad somebody remembers. I'm glad, because we had very heated, difficult debates in the National Forum for the transformation of the legal profession. I'm glad someone remembers that, because it's easy to forget.
So I just wanted them to know that we appreciate you.
Thank you.
JP Tlalezi?
Thank you, Chief Justice, and good afternoon, Justice Wendy.
Good afternoon, JP Tlalezi.
Yeah, just a little about the general traditions of the judiciary.
Yes.
When you are in KZN, you are an acting judge despite the experience and everything that you've got.
Yes.
I wonder whether you made some research on this. Now, if you were to be transferred or appointed there, how is it somehow going to affect the rankings in that court? Might it not cause some problems that the JP may have to deal with?
I understood that once a judge, always a judge.
Yes.
And I understood that, at first, I was called AJ. Call me what you like. It's not something that really bothered me. But my 8 years in the judiciary is not going to be erased just because I'm now moving on to another court. So if I am accepted, I will fit in appropriately in terms of rank. There is no rule that says otherwise, but all that is regulated is just the process of the lateral transfer, and which requires me to come before the JSC.
Thank you.
Thank you.
Thank you, Judge Swind. You're excused.
Thank you, Commission. Thank you, CJ.
Shall we clear?